ನೀರ್ ಬಾಟ್ಲು ಸರಿ ಬಾಯ್ 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 ಫೋನ್ ಮಾಡೋದು
ನೋಡ್ತೀವಿ.
List number 3, page number 2, serial number 5, 6, page number 3, page number 4, serial number 7 to 12, 7 to 12, page number 5, 13 to 22.
Serial number 13, Your Lordship. 13, Your Lordship. In this, I have to file a affidavit, my lord, regarding status of employment, my lord. I had sent the copy to the petitioner. She has to send it back. Kindly have this matter Thursday, my lord.
What has happened? The proceedings before the Shimoga court filed by the wife. But
No, anyhow, he has to file, we'll give him a finally.
what happened? Conciliation was not stayed. It shall go on. 2 times he has went to the Shimoga from Bangalore. She has not turned up for mediation.
Yeah, mediation.
Therefore,
This
conciliation
is not
may be
post.
stayed.
It is not, since the matter is stayed, mediation
When is
not.
it going to be listed? When is it coming up for the conciliation?
Conciliation. 2 times this.
No, when is the next date? Forget about the 2 dates.
22/4.
Hmm?
22nd.
I'll ask my party to attend the.
But
Please.
22nd for is a long way. We are taking it up on
Thursday.
this Thursday. Let's this matter on Thursday. Finally, no further adjournments.
Please.
At the request of land counsel for the respondent.
Respondent in first matter, petition in second matter.
On behalf of the wife.
Please.
Oh.
Interim order is there.
Interim order earlier granted is extended till then.
Please.
Yes. We have to file objections.
I will get this objections by next week.
At the request of the land counsel.
Interim order may be extended, my lords.
Interim order.
A week's time, interim order earlier granted is extended.
8-4.
Serial number 16, my lord.
Huh.
Only received a notice from this honorable court, my lord. They have not served any copies to me.
So if you wait, when once he
1/6.
comes, we can ask him to do it.
Please.
So let the matter be called.
Please.
Yes.
Page number 6, serial number 23 to 25, page 7, 26,
My lords,
page 1.
I want to mention serial number 26.
I
My lords,
appear,
this
my
is the Admiralty matter my lords heard last week. My lords, a Bombay council has been instructing me. Her mother passed away a day before yesterday, my lords, and they filed a further they've served an additional affidavit on me with a document. I need some time to.
I
seek
must
instructions.
only
I
say
apologize.
the
I
arguments
informed-
are being happening. They are only legal arguments. There's nothing factual to verify.
I'm-
I understand why it's our sympathies with everybody, but this is, my lords,
Was it informed to you in advance?
it was informed, my lords, yesterday when our flight tickets and all were already booked, my lords, we were to be here. They are booked in advance because, my lords, it's substantial expense. But that's, apart from that, the point was, as your lordships had heard us, was only whether, my lords, interim relief, a suit only for an interim relief can be granted. These are all legal arguments. You don't need instructions.
No, because
I
he's coming from outside. You should have told him.
My lords, I told him as soon as I found out, my lords, when When I found out, I have informed him. I apologize.
Is he
It is
coming?
just unavoidable. Please, my
When
lord.
is he coming? The
Not come-
council.
No, his counsel is not coming. If it is posted sometime next week, I will get adequate
She wants
instructions.
time to take instructions. My
Because they
point
filed
is,
an
my lord,
additional
it's
affidavit,
legal arguments. What instructions? Nobody gives instructions to make legal arguments.
I leave it to my lords. I'm making a request. There is a genuine difficulty. That is why I'm
There is
making
no
a request.
factual
I've informed them.
verification. It is entirely on law. Someone has to argue law. Nobody is going to, clients don't indicate what law is to be argued.
Finally, list is matter.
May I make one request, my
Eight.
lords? No, my
If I may
only
request
earnest
nine.
request to the court, my lord, let it be called out at 2:30. I will come, I have,
No, please understand court's difficulty. Once you, both of you advance arguments, I will dictate the order on the bench itself. And I can't have, already on the last occasion, substantial time is spent by this court.
That's correct.
And it can't go on every time. I want both of you to conclude at a go.
no, my only point is, my lords, since she was to begin, she can have the benefit of a few judgments that I have to argue. There are two other,
Give her,
No, that I-
and I'll give you a date on at 2:30, whatever both of you is, for your convenient to both of you. That day, you both of you have to conclude it.
Yes.
Because this piecemeal argument, I cannot remember.
that's the whole point. But may I only at least make one request? There are two other applications, extremely short. One is for amendment. Can at least that be considered today? They filed their counter, my lord. For that, they don't need instructions. At least that can be taken up. At least our trip will not be wasted, my lords. Those two small applications can be considered today. That's my only request to the court.
No. We'll not spend any time on this. When is it? Which day?
I would say, my lords, would my lords accommodate us day after, my lords?
My lords, sometime next week.
Day after may not be possible. Day after may
My
not be
lords,
possible.
if I may request.
We'll
the
have
9th
it
or
either
10th.
you from on 7th, not 7th, 8th, 9th, any of those 2 days, or else again on 16th.
No, my lord, it will go very, please keep it on 9th.
9th.
9th,
9th,
yes.
can it be at 2:30?
9th at
my lords?
2:30.
I apologize again, my lords.
Yes.
I'm most grateful.
Please, I hope, my lord, there are no further adjournments because
No, she'll not. We'll leave it there. Yes, next.
Number 1, serial number 1, O Mahesh, for appellant. Yes, Raju.
I appear for the appellant.
Yes.
Yes. Blood appeal by the insurance company
Hmm.
of a motorcycle bearing registration number KAEV 9663.
Insurance company is on what ground?
Pardon?
Insurance company's appeal is on what ground? On liability, quantum?
Blood, it's question of collusive claim.
Oh.
I'll state the facts. Yes, collusive claim. Blood, the injured malord is minor, aged about 17 years, by name Madhu. It was projected, my lord, that he was the pillion rider of motorcycle KA26E 7778. Rider of which said to be one Suresh. The offending motorcycle, my lord, is bearing registration number KAEV 9663. Blood, the minor, not the claimant, actually was riding the motorcycle bearing registration number 7778 of E7778. But after the accident, my lord, he has been shown because he didn't have the license and he was a minor. He was shown, my lord, as a pillion rider, and the accident was from the other motorcycle, dashing his motorcycle from behind. The whole, my lord, the police records have been manufactured in collusion with, my lord, the respective owners of the motorcycle.
Yes.
Yes. So the injury, my lord, said to have been caused is, my lord, fracture of left zygomatic arch.
Yes.
Right here, I would like to mention, my lord, If the offending motorcycle, my lord, dashed against the, my lord, the other vehicle on which the injured was a pillion rider, strangely, my lord, the rider of the motorcycle has not been injured.
Now, before going into all this, what are the objections or the statement filed by the insurance company? Give the TCR.
We have taken up a defense that the negligence of the motorcycle in which, my lord, the injured was thing, actually he was the rider and he had no DL. The insured of our vehicle, my lord, argument.
The respondent is not aware. The respondent is not aware whether the Honda Activa was driven by the person authorized to drive and that he had valid driving license to drive the same.
He was a minor, my lord. He was a rider, but he was posed as a, my lord, as a pillion rider. But I would like to invite your lordship attention to the nature of injury, my lord.
And to substantiate your case, who were examined to say that he was not a rider of the pillion rider, but a rider. Please
That RW1, my lord, was examined.
your
RW1, my lord.
RW1 is your officer.
Senior
Officer
assistant,
of the company.
senior assistant of your office.
And the exhibit R1 and R2 were marked in his evidence. It is his
Exhibit R1 is
statement.
the authorization letter, R2 is insurance policy.
Policy.
Yes.
So now, my lord, I would like to, my lord, the probabilities. The injury, my lord, left zygomatic arch. This type of injury would not be caused unless he was riding the two-wheeler.
What was the suggestion put by you to the doctor in this regard?
Doctor is not examined, my lord.
Doctor is not examined.
Not
Not
examined.
cross-examined. So then how do we, how the court can,
Para 16 of the, my lord, judgment may kindly be looked into.
yes.
In spite of that, my lord, the award has been made. My lord, what I am trying to canvass before a lordship is, my lord, that this type of injury would not be caused unless he himself, my lord, has.
Who has to say this?
Doctor is not. My lord, if the doctor were to be examined, I would have, my lord, elicited from him. This type of injury would not be caused in the light of the, my lord, the pleadings made by the claimant.
So you could have examined some doctor saying that whether in injuries of this nature, this accident, the pillion rider would sustain those kind of injuries or not. And what is the
Then the objection is that that doctor is not competent to speak
yes,
about that.
next.
Now you have to kindly see the rider, my lord, and the owner have remained absent and expert. That
Yes.
shows, my lord, the collusiveness of the. So therefore, my lord, my respectful submission.
Yes.
In MFA 1485 of 2017, my lord, a miscellaneous petition was filed.
Computer people.
This is on these grounds, my lord, the
Entire this thing is it's not blur. It is freezed. Ask them to come. Let somebody be there from that computer. I told the registrar also. Ask them to come. Yes.
yes. On this basis, my lord, the appeal has been filed by the insurance company, my lord.
Yes. Please come.
And in the absence of, my lord, a doctor's evidence,
Hmm.
the award amount, my lord, is on the higher side.
Yes, agreed with the order supervised. PMVC number 6496 of 2008, dated 18 December 2010. The insurance companies before this court questioning the quantum as well as the liability. It is a case of the claimant that on 26/3/2008 at around 11 p.m., the claimant, along with his relative, one Suresh, was returning on Suzuki Samurai motorcycle. Uh, the claimant was a pillion rider. On their way, when they reached near Gangamma Temple Road, suddenly Honda Activa, belonging to the second respondent, came in a rash and negligent manner and dashed against the Suzuki Samurai, wherein the petitioner was traveling. Because of the injuries he had sustained, uh, depressed fracture of the injuries are at page number 13, extracted. The court had held that, basing on the police records and other evidence available on record, the accident had happened because of the rash and negligent driving of the driver of the Honda Activa motorcycle. And as the same is insured with the insurance company is liable to pay the compensation. When it comes to the compensation, the considering the two injuries, two fracture grievous injuries, court had granted an amount of rupees 30,000. Then coming to the medical bills, basing on the medical bills that are produced, court had granted an amount of rupees 41,043 towards the medical expenses. Somebody from your team, let somebody be there in the court, because when you're doing on a trial basis, things are not working. We have to keep on seeing it. So it has to work here also. Tell the registrar. The and towards attendant and transportation charges, an amount of 4,000 was awarded. Loss of amenities, future inconvenience, an amount of rupees 20,000 was awarded by the court. Altogether, compensation of an amount of 25,043 was awarded. Next para. When counsel, according to the insurance company, submits that the claimant was not a rider of the way, pillion rider, but he's a rider as he is 17 years old and he is not having a driving license. Court had considered without considering and as he was not having driving license, it is projected that he is a pillion rider. Learned counsel, referring to the injuries that are sustained by the claimant, particularly the left zygomatic bone with surrounding soft tissue swelling. It is submitted that this injury could have not been caused if he is a pillion rider, but this can only happen in the case of the rider of the vehicle. It is submitted that the doctor was not examined. In spite of the same, the court had granted the compensation. Next paragraph. The
Enhancement appeal.
your enhancement appeal is there.
Please.
Where is the scope for an enhancement without
Yeah,
examining?
pain and
the-
suffering, very meager amount has been awarded by. Loss of ability is also very meager. He is a second PUC student.
Huh?
He is a second PUC student at the time of accident. My lord. He is not attending the.
No. Unless and until you examine the doctor, how will anybody say what is the disability sustained by you?
Unfortunately, he is not examining the doctor. my
But
lord.
we can't
Because
grant-
of pain and suffering, at least some amount has to be enhanced. Loss of amenities and pain and suffering.
Loss of amenities also, unless and until the doctor's evidence is there. I was looking at it, how 20,000 is
He
granted.
can this summons 2-3 occasions, he is not come forward to the lead evidence.
It's not the problem of the court, isn't it?
At least some
The,
amount, it is a student.
What did you? Is contentions here. Court has granted compensation. It is submitted that both on these counts, the appeal of the insurance company needs to be allowed. So in the starting, the agreed with order so and so. Insurance company had preferred MFA number 3162 of 2011, and the claimant had filed MFA 1485 2017, seeking enhancement of the compensation. The counsel appearing for the claimant submits that the court, the boy is 17 years, the claimant is 17 years old. He is doing his PUC, and because of the injuries sustained by him, he had sustained disability. All these issues were not were not considered by the court, and the compensation that is awarded by the court is not a just and reasonable compensation. Expera, having heard the learned counsel on either side, peruse the material on record. First, coming to the contention of the insurance, the counsel appearing for the insurance company. That first, on the ground of that the claimant was a rider, but he is not a pillion rider. The police records reveal that he is a pillion rider. The insurance company had not taken any such objection in their written statement, and even in and they have not reduced any evidence to show. And basing on the medical evidence, the learned counsel tried to impress upon the court that those kind of injuries would not take place if he is a pillion rider. The court is not the expert to understand or deal with these kind of things, and the burden lies on the party who alleges that those are not the pillion rider will not those kind of injuries will not happen if he's a pillion rider, but only happen in the case of a rider. In that case, they should have reduced the evidence. They have not reduced any such evidence, and this court is not inclined to take into consideration the contention raised by the insurance company, and the tribunal had rightly held that the accident had happened because of the rash and negligent driving of the driver of the offending vehicle. Then when it comes to the compensation, no doubt the claimant has not examined the doctor. But as far as the injuries are concerned and the medical expenses, basing on the medical evidence, the court had rightly granted the compensation. Coming to the attendance and transportation and the loss of immunity is also, considering the nature of injuries, court had rightly granted the compensation. Coming to the aspect of the enhancement, without examining the doctor, without placing all the material on record, the court cannot come to any conclusion with regard to the disability or otherwise, and the compensation that needs to be awarded to the claimant. In this case, in the light of the evidence that is placed before the court had rightly granted the compensation, and no grounds are there to interfere with the order passed by the tribunal. Accordingly, both the appeals of the insurance company as well as the claimant are dismissed, and the amount in deposit shall be forthwith transferred to the court. Yes.
Question number 2. Question number 2, O Mahesh.
I appear. Number 2, my lord.
Yes.
Yeah. I appear for the appellant, my lord, in both the appeals. Appeal by the insurance company.
MFA 2477 arises out of?
MFA 2477 arises out of MEC 810 of 2010. And MFA 2476 of 2012 arises out of MEC 809 of 2010, MECT Udupi.
How this one other is 809. 809.
809 of 2010.
Yes. You are on what ground?
Found, my lord, that they were gratuitous passengers claimed to be, my lord, the employees of the insured lorry. Lorry bearing registration number KA 21 A 1439. In this respect, my lord, I invite your lordship attention to the claim petition filed, my lord, in MFA 2477.
Before going into that, we will see the finding of the court.
And why I am trying to this thing, my lord,
Hmm.
they were just wanted to point out the pleadings, which is pleading is, my lord, contrary to the evidence. That's why, my lord, I just wanted your lordship to look into the pleading first, so that can appreciate my subsequent submissions in regarding that, my lord.
You are referring to MBC 809.
My lord, 810, MEC 810.
You that?
That is in respect of MFA 2477 of 2012.
What the file LC is here.
Name of the claimant, my lord, is Umesh. Your lordship got it, my lord?
Yes.
Column number 4, my lord, and 5 may kindly be looked into.
Hmm.
4, my lord, say loader.
Hmm.
The name and address of the employer, my lord, is left blank.
Hmm.
For that, my lord, I come to the conclusion, the complaint made, my lord, by the other claimant, man, where he stated that while the lorry was proceeding from Smolad to Goa carrying fish load, this person, my lord, got into the lorry.
No, you're relying on this MBC number 810 of 2010. Now we will complete the PQ also, which you want to point out.
Okay. That he was not an employee of the insured.
On 25th of March 2010, at about 5:45 hours, while the petitioner was traveling in the vehicle so was coming from Goa towards Malpe after unloading the fish in the said vehicle, and when the vehicle had reached near so, according to this claimant Umesh, he is a loader.
Right, that's why, my lord, I am just pointing out my lord, the pleadings. In the claim petition, my lord, he says loader, but name and address of the, my lord, the employer is left blank.
Yes, that is one aspect. Next.
Yeah. Then, my lord, I invite your lordship attention to, my lord, the statement of, my lord, the claimant in another MEC case.
Yes.
That is the FIR, my lord, filed by him by cleaner Max. It's in Kannada. I'll just point out, my lord.
Now, in the next one also, MBC number 809, his claim and in the statement they say that the same statement coming from
I'll come to that, my lord. His statement may kindly be looked into in particular to this claim, my lord. He says that he was a picked up person on the way. ನನ್ನ ಪರಿಚಯದ ಇದ್ದ ಉಮೇಶ ಆತನು ಮಲ್ಪೆಗೆ ಬಂದಿದ್ದನು. So the friend of, my lord, the other person who claims to be the cleaner of.
Priyanka GM.
It is in Kannada, my lord. I just read out to your lordship.
Where is she? If she is appointed, she should come and appear.
It complained by, my lord, by this thing, claimant in MEC 809 of 2010.
Inform the legal services authority people and pass over afternoon. Ask them to inform her. She didn't turn up. Yes, next.
Serial number 3. Omayesh for appellant, Venkatesh R. Bhagat,
For the respondent, my lord.
The respondent.
I appear for the appellant.
Yes.
Lord, this is a case of, my lord, a claim petition filed under 163A and 166.
Hmm.
Injured is, my lord, one Mr. Manju, said to be a carpenter aged about 28 years. So stated that he was traveling in the insured auto.
Mr. Mahesh, if you can
Yes.
tell the court, insurance company's appeal is on the liability or on the
Yes,
contract?
on the liability,
Yes.
my lord.
So if you can come straight away to that particular finding of the court, you can save the
Yes.
court's time also, not required all the facts.
That facts would be necessary
So
for
that then you
appreciation.
can tell the court, once the court understands what is the observation, then on basing on facts, what is, how you are trying to distinguish it, then the court's time is also important. Please come to that finding.
Yes, my lord. You have to kindly, my lord, turn to, my lord, ink page 17,
Yes,
para 14.
yes, please read.
RW1 in his chief examination deposed on par with his case. In the course of cross-examination, he has deposed that he was acquainted with Manju prior to the accident. When it was suggested to him that he was in possession of the key, he deposed that he parked his auto by the side of the road and went to call the coolie workers. He denied that the said vehicle was driven by him and due to his negligence the accident caused. The respondent one also produced some document. Exhibit R1 is the certified copy of the order sheet in CC number 86 of 2010. Though this document reveals that after taking cognizance against the respondent one, on the basis of the private complaint filed by the petitioner, in spite of opportunity given to the petitioner, he did not appear before the said court to adduce his evidence, and the said complaint has been dismissed. Though the petitioner has produced exhibit P1, which is a certified copy of the order sheet in CC number 86 of 2010, the petitioner has not produced the order sheet in case of the subsequent that the case subsequent to the date of taking cognizance by this court. In spite of the contention by the respondent one that the said accident was due to the negligence of the petitioner and the petitioner did not appear before the court and hence he has been acquitted. The petitioner has not produced entire order sheet exhibit R2 in the certified copy of the B report statement of the witness. Mahazar enclosed to B report, which are also produced by the petitioner herein, exhibit R8 to R12, are nothing but the document produced by the petitioner as per exhibit P11 to P15. Exhibit R13 is the certified copy of the private complaint filed by the petitioner before JMFC Court, Somarpet. On going through the entire oral as well as documentary evidence produced by the petitioner, it is very clear that in relation to this accident, no complaint has been registered by the jurisdictional police station. But the petitioner has lodged private complaint only on 4/3/2008. Accident number 2007. When the JMSC court referred case to Bailekuppe police station on the basis of that a case has been registered in crime number 58 of 2008 by Bailekuppe police station and in the case B report has been submitted by the investigating officer and the petitioner has challenged the said B report by filing objection and after recording the sworn statement of the petitioner, cognizance was taken for the offence punishable under section 279, 338 of IPC. Against the respondent number one hearing, and summons have been served on the respondent who appeared before the court and obtained bail. Subsequently, the petitioner did not appear before the court, and the complaint filed by the petitioner has been dismissed. That is important. Further on, going through the objection filed by the petitioner, it is very clear that soon after the accident, he was admitted to Community Health Center, Kushal Nagar, and he has stated he sustained injury due to self-fall, accident fall. Hence, no case has been registered. However, on going through the contention of the respondent number 1, it is very clear that the petitioner has sustained injuries due to the accident while using the auto rickshaw bearing registration number KA12 85355 belonging to him. Herein, admittedly, no FIR has been submitted before the jurisdictional court with regard to the criminal liability about the rash and negligent driving of the driver of the said auto rickshaw at the time of accident. Herein, this tribunal has to see whether the accident caused due to the negligence of the petitioner herein or due to the respondent number 1 herein. The respondent number 1 says that he parked his vehicle by the side of the road and went to take coolie worker. At that time, the petitioner took the vehicle and drove it in a negligent manner. He lost control and it toppled down. But the allegation by the petitioner against the respondent 1 that when he was traveling in the offended vehicle, which was driven by the respondent number 1, due to the rash and negligent driving of the respondent number 1, the accident caused when in private complaint lodged by the petitioner, B report was filed. Though he challenged it, the case was registered against the respondent 1. The petitioner did not prosecute the said case. Further, though he stated before the doctor he has treated him after the accident, that the accident caused due to self-fall. Though he took treatment at Community Health Center, Kushal Nagar and Government Hospital, Madikeri, and he produced Exhibit P13 wound certificate, he had not examined the doctor who treated him for the reasons best known to him. And also, it is pertinent to note that in the said accident, the respondent 1 has not sustained any injuries. If really this accident caused due to the negligence of the respondent number 1, when the petition number 1 sustained grievous injury, this respondent 1 must have also suffered some injury. These are sufficient to prove that the accident caused due to the negligence of the petitioner, and it supports the case of the respondent number 1 that the petitioner took his vehicle without his consent and caused the accident. So I hold that the petitioner has failed to prove the rash and negligence of the respondent number 1, and he has driven the said auto rickshaw at the moment
this
of
petition
the
is treated under section 163A.
But they Malad, you have to kindly see 163 or 166. You have to kindly see the pleadings, Malad, whether he had come before the court with clean hands. You have to kindly look into the Malad, the claim petition, how it was presented.
Yes.
Whether this type of Malad, the character of the Malad can be. Then para 16 Malad, I'll then just read Malad. This petition has been filed under section 163A of IMA Act, which provides for compensation as per second schedule. Though the accident caused due to the rash and negligence of the petitioner, he is entitled to compensation under section 163A of the IMA Act. It is stated that respondent number 1, that offending vehicle is duly insured with the respondent number 2. The respondent number 1 has produced a copy of the insurance policy which is not marked. On going through this document reveals that from 9/8/2006 to 7/8/2007, it was insured with the respondent number 2. So it is proved that as on the date of the accident, the offending vehicle was duly insured with the respondent number 2. And the respondent 2 is liable to pay the cost. This is how Malad the tribunal proceeds.
Yes.
My respectful submission, whether this type of Malad can be, you respect kindly Malad, I'll invite your lordship attention to my lord in page 9, para 1 of the judgment.
Yes.
This petition is filed under section 163A with section 166 of the IMU Act claiming compensation. Even my lord, my respectful submission, it does not come under the purview of section 163A. The reasoning which I may not read out to your lordship, that say the auto was parked and he himself drove. Inconsistent plea, my lord, inconsistent story.
Yes.
Wait, my lord, complaint has been filed. That also came to be dismissed. B report, my lord, that there is no accident. Under these circumstances, whether the reasoning of the tribunal, after my lord considering the my lord the facts and circumstances, can be said that his claim has to be considered under section 163A.
Yes. What do you say?
Under these circumstances, my lord, the appeal of the company has to be allowed with heavy cost to the
Yes.
My lord, first of all, this application is filed under section 163A of the motor vehicle accident, my lord. In
What is
this
this 166 then?
163A,
Oh, you say that 163A, then if that is the case, straight up you come under 163A, court would have not gone into all these things about the rash and negligent driving and all.
166 is like application for the compensation, no, my lord. He need a compensation. Though the fault is on the petitioner, still the application is filed under 163A, my lord.
What are the issues that are framed? Whether the petitioner proves that on so and so, the respondent number one so and so was traveling, drove the same in a rash and negligent manner. Due to that, auto rickshaw capsized and accident occurred.
Yes. In justification of this, my lord, even para number 17 has to be looked on, my lord. A doctor is also been examined in this case, my lord. The petitioner has produced several documents, but he has not produced any document with regarding to medical expenses. Exhibit P13 to P15 reveals that he has suffered a grievous injury with fracture. He also examined Dr. Sriranga as CW1 who has
We're not
deposed
on
that
all those issues. You have the prime issue of this. That you to tell the court. You make your submissions on that. Though you will take a number 163 and ultimately your case is that it is so and you wanted compensation under 166.
163A and 160.
Doesn't appear to be. Give that TCR 1 second. It can't be alternatively.
My lord, it can be taken tomorrow. I'll seek some instruction.
After spending this much time, will not adjourn.
Please. My lord, section 166 subclause 2 may be looked on, my lord.
Where is that? Give it in the other case. This is all in Kannada. There are two cases. Give the other TCR.
One.
No, you have given two just now. You're shouting like that. Keep him muted till it's required. What is your income? What was stated? If you're seeking compensation under 163A,
I'll just take you now.
it is stated in the petition that he was earning 20,000 per month.
Yes, ma'am.
Then how are you entitled?
My lord, I'll just take my lord. My lord, page number, in judgment, page number 17, just before para number 19, my lord, it is stated that the petitioner petitioned that he was earning 20,000 per month, but admittedly there is no document. This accident had taken place in the year of 2008 and he was aged about 28 years at that time of the accident. Hence, I deem fit to consider his daily income of rupees 200. The court has considered as rupees 200, my lord.
Please understand, when you say that you're earning 20,000 per month.
But no document. I apologize.
So all admitted facts need not be proved when it comes to your pleadings. If it is other side denies, that's a different aspect. While considering the computation, court will decide whether it is there or not. When you're saying 20,000 on the face of it, how can you maintain a petition under 163A? You cannot, number one. And court had dealt with everything as if it is dealing with a petition under 166. Suddenly it says it is 163A. He doesn't have to prove negligence. Then in that case, why was an issue framed in that regard? Pass over, this has to go. We'll allow the appeal of the insurance company.
I'll just get back, my lord. I'll just go through and pass over.
Pass over.
Please.
No, I'm indicating that we'll allow the insurance. Otherwise, if you have any submissions to make, please make. Yes. Pass over.
Yes. So number 4, O Mahesh for appellant.
Yes, Mr. Mahesh.
TV Kalpana for R6. O Mahesh sir.
Unmute him.
I appear for the appellant.
This is on liability or on financial?
It's on the liability, my lord. Though there is no insurance particulars.
Come to that finding.
Yes. But in page 19, para 60. The first respondent is the rider, the second respondent is the RC owner, third respondent is the insurer of the vehicle which caused the accident. The respondent number 1 to 3 were placed ex parte. Here, my lord, I would like to mention that an application was filed, my lord, under ordinary for set aside the, my lord, and to give an opportunity that was rejected. Therefore, my lord, this appeal has been filed. The respondent number 1 to 3 were placed ex parte. Discussion in point number 1 shows that the respondent which has caused the accident, the charge sheet does not reveal on violation of condition of the policy and there is no evidence on non-existence of policy. However, it is pertinent to note that petitioner have not mentioned the policy number and details of the policy particulars. Later, petitioner counsel submitted a memo submitting that the concerned police have also not furnished the details of the policy. Further, the petitioner advocate only orally submitted that even after the approaching the concerned authority and the person, not able to get the details of the policy particulars. My request for in these circumstances, matter requires to be remanded because insurance, all the respondents were placed ex parte and the appellant insurance company made an application under order 9/13 That was rejected. After that, my lord, this appeal is filed before this court. And admittedly, my lord, even the observation of the tribunal, no policy particulars are forthcoming, no evidence that the vehicle is insured. Merely because the vehicle involved in the accident is not disputed, the insurance company cannot be held liable. And it is respondent 1, 2, 3 are jointly and severally liable. The claim petition, you will kindly observe, my lord. No policy particulars are forthcoming. Even in column number 16 of the claim petition, my lord, policy number is not forthcoming.
Who appears for the respondent?
That is PV Kalpana. PV Kalpana?
Is she there online?
No, ma'am.
Hurdle and counsel for the appellant. No representation for the respondents. List this matter as part heard tomorrow.
Cell number 5.
Ma'am, for the appellant, my lord.
SG exec for appellant. Yes.
The appellant will not dismiss. The claim petition was dismissed by the tribunal
On the ground?
on the ground that there is a delay of 3 days in filing the FIR.
Uh,
3 days delay in filing the FIR,
yes.
and that the accident has not taken place with the whatever the insured vehicle. It was on the other hand, as per the record, it's the 4-wheeler has caused the accident, not the 2-wheeler. It's on that ground.
Please come to that finding.
Yes, ma'am.
Let's read issue number 1,
Issue number 1, my lord.
para number 10.
Yes. The case of the petitioner PWM is that when he was proceeding as a pillion rider on the motorcycle.
What is this vehicle? Motorcycle.
Motorcycle. On 4/8/2010 at about 10:30 a.m. on VFW Road near HMT School, the rider of the motorcycle bearing registration number KA02 HB5478 went in his opposite direction and dashed against the motorcycle bearing number KA02 HF6866, wherein the PW1 was going, and hence he fell down and has sustained injuries. In this support, PW1 has produced 2 copies of FIR with complaint, charge sheet, Panchanama, sketch, and MUA report. Exhibit P1 to 4 to 6. The aforesaid documents corroborate the case of the petitioner, but the respondent number 2 has taken up contention that the accident was not due to the rash and negligent riding of the motorcycle bearing registration number KA02 HB5478 as alleged by the petitioner, and a false case has been filed against the rider of the motorcycle bearing registration number KA02 5478. The respondent number 2 has examined its legal manager RW1, who has deposed that the motorcycle bearing registration number KA02 HB5478 was not involved in the accident, and has deposed that as per medical records, its admission notes, case sheet, discharge summary issued by Ravi Kirloskar Memorial Hospital, PW1, the petitioner fell from the 2-wheeler after being knocked down by four-wheeler and has sustained injuries. In this regard, the learned advocate for the respondent number 2 has cross-examined PW1 and recited the fact that in the medical records, it was noted that while he was going in two-wheeler as pillion, the motorcycle knocked down by a four-wheeler. It is also pertinent to note here that the learned advocate for the respondent who has confronted all the medical records with wherein such entries found in since PW1 has admitted the case was true somewhere marked exhibit P2, P2 and P3 at exhibit P17, exhibit R4 and exhibit P8. Hence, it is pertinent to reproduce the said portion of evidence of PW1, which runs thus. It is true that it is noted in exhibit P16 that fall from two-wheeler after being struck down. The said portion is marked as exhibit R1. I will just stop for a moment, my Lordship McKenzie. Exhibit R1. It is true that it is noted in P17. Admission notes that the history of RTA fell from two-wheeler after being knocked down by a four-wheeler and sustained injury to right ankle. The said portion is marked as R2. It is true that even in the case sheet, exhibit P17, the four marked facts restated as history of RTA fell from two-wheeler after being knocked down by a four-wheeler. The said portion is marked as exhibit R3. I was at the hospital as inpatient for a period of a week. It is true that exhibit P8 states the aforesaid facts, that is R1 to R3. Said portion is marked as R4. At this juncture, it is argued by the learned advocate for the respondent number 2 that the aforesaid documents are 2 to 4.
So police have filed the charge sheet.
Yes, charge sheet has been filed.
Yes, Mr. Krishnaswamy. Police have filed the charge sheet
Yes.
against the rider of that offending vehicle, two-wheeler.
Yes.
My lord, their own admission.
No, admission, what happened, my lord?
The examination
Very first
chief,
day-
the claimant himself admits that there is a reference that four-wheeler.
No. Why I'm saying because very first day of the first opportunity when he went to the hospital, he was taken to hospital on 4/8 accident has taken place. He has not stated four-wheelers history at all.
No,
It was
in
only
that
struck
case-
down by,
In that case, what you should have done,
No.
or the claimant should have done,
No, one submission.
if he has not stated anything,
Yes,
if
yes.
something has been written, you should have done something with that MLC.
No,
Or you should have examined somebody.
That's true, my lord. That's what has happened, my lord, in this case, all these records, entire medical records were called for. I mean, at the instance of the petitioner alone, the claimant alone, for the purpose of proving his injury and medical treatment he has taken, injury sustained and the disability factor, etc. Not as the purpose of the accident purpose, to prove the facts of accident as such, but history, one of the column.
It is
No,
not that.
one submission I
When
would
the-
like to make.
One minute. When the medical records are placed before the court, that is, those are the documents of the first instance,
Yes.
which were informed about the accident. And those documents.
That's why I'm coming to
those
the
documents-
R16 may kindly be seen.
No, those documents are placed by you.
Yes, that's
You are
correct.
relying on those documents for a particular purpose, saying that this is all the injuries I have sustained and these are the treatment I have taken. Part of the document you cannot admit and part of the
Yes,
document
that
you
I have
cannot
to own
deny.
it. I have to own it for this reason.
Uh.
But that's what I am explaining how
There
it
won't
has
be any
happened.
specific reason. Once a document is marked, it is
What is-
marked.
Marked, yes.
It is for the court to consider it.
Consider it. How
You
it is
cannot
to-
say, look at the document for the
No, I'm
purpose
not
of
saying
medical
look at
case.
it all. The differentiation can be done in this way, my lord. Because very first day when I went to the hospital on 4/8/2011, sorry, 10, the history was, it was struck down and fell down from a two-wheeler and injury has taken place. No four-wheeler history at all. It was not mentioned at all. Exhibit R16.
Where is that?
P16 may kindly see.
Take
P16.
that.
And subsequently in discharge summary and admission note next day when the hospital authorities written according to their own this thing.
Let's see, let's
It is included as four-wheeler.
Take exhibit P16.
Yes, exhibit P16 may kindly be seen.
This is the outpatient card.
This MLC record, it is there. Medical legal case has
That's
been
not
registered.
P16.
No, that is, no, not history I'm saying. Once he was, the reason was, reason for admitting.
Is that MLC?
That's what I'm saying. Exhibit P16, my lord.
3 outpatient card of patient.
No, not operation.
P16, that's what I can see from page 26.
Fall from two-wheeler after knockdown. That's all. It is P16. Lordship may kindly see. This is the very first day. The next documents were all
4/8.
written subsequently.
1 minute. 4/8/2010.
Yes, this for 4/8/2020 the accident took
All
place.
from
For firm
two-wheeler
knockdown.
after being,
Huh? Pardon?
something is there after that.
No, it's only this much is there. It's not the four-wheeler.
Something is there. What is that? RTA fall
Yeah.
from the two-wheeler after being,
Just 316. P20. The 16 and 16.
R3.
16 then.
I'm referring to 16.
That's a form. It is in like a format, Your Lordship.
Huh?
It is in a format. First day, this was the MLC record prepared by the.
This is
first-
what it is, Mr. Counsel.
Yes.
Can you see this?
Yes, this is the one. Yes, Lord. Fall from two-wheeler after being knocked down. It's all. Then it is marked as R1, exhibit R1. There was no two-wheeler theory at
so
all.
this is
Sorry,
4/8.
two-wheeler or four-wheeler theory at all.
This is 4/8/2010.
Yes.
Then
Thereafter,
where- no, for the
next day he
first
was
day-
admitted. Next day he was admitted for operation on 5/8. On that day in admission notice and admission notes and other things, it was mentioned as four-wheeler. How it has come there, because he was a patient at the time, he was not so in a shock, but how that four-wheeler included, I don't
Now,
know.
what did you do with that is the question.
Patient, no. Then operation was done thereafter. Pardon me.
Not that.
Yes. What he did do then.
Something has come into the documents in the whatever discharge summary and all.
That he came to know only when it's produced before the court as a.
Then you should have done something at that time. What did
That
you
is
do?
one lacking is there. That's I understand. There's one ought to have been examined the IO or
Then
witness.
without that, your own documents
Then-
have to be looked into.
Then in such a circumstances, the Supreme Court says, my lord, there are three judgments on that point. When the respondent asserts that such a discrepancy is there, there is the FIR is false or charge sheet is false, etc. What action he has to take? What action he has to take? He has to complain about this, and he has to give evidence to show that it is a four-wheeler. It has been involved in the accident, not the two-wheeler. Its burden is also on him, on them, on the respondent also, because this is their assertion. Where oral evidence is not enough.
In the criminal case, where will be the
Yeah, that's the reason.
respondent?
That's the reason. It's not criminal case. It is the reason that it is a principles of preponderance of probabilities as civil suit is to be decided as the MSC case. MSC tribunal. Your lordship is aware of that. Not as beyond doubt as such in the criminal case what the court is doing. But in this case, when the motor accidents claims tribunal, your lordship is aware of this. How it is the proof has to be the degree of proof is to be looked into, because claimants are only thinking of getting compensation from the accident they have suffered, and not that the punishment as such is
No
concerned.
dispute with all these propositions.
Yes,
Party who has come before the court filing a petition.
that's what I certainly I said.
Burden lies on you, whether we have discharged or not. If you have discharged, then the burden lies on them to report
According
that.
to me, my theory from beginning till end was only two-wheeler and two-wheeler. Then
In the light of the documents that you have placed, not they have
no,
placed.
this medical records is mine only. That's correct.
In that case, you have failed to do it. Court had right, it is.
Right. One
Please
submission.
come.
One submission. Lord. One submission. An alternative prayer I'm making.
Yes.
If another opportunity is given, we will take necessary steps for the purpose of proving this is demanded, my lord.
Not an MBC of
I mean,
2000.
my prayer may kindly be.
I'll record that.
I got two judgments, my lord, on this point. I will just.
Please pay pass.
Yes.
Income per month is claimed as 25,000.
No, no.
Income per month is claimed as 25,000. 163A petition. That
This is
all.
163A. Then,
The claim petition
no, it is
itself,
under 166.
163A.
No, 3916 is under 166.
160.
Yes.
Please pass. on.
This is 2018 5 Supreme Court case 656.
Yes.
This para 5, your lordship, can see. The tribunal has noted the evidence of the defense witness that the jeep in question was nowhere near the area of the accident. The tribunal, however, opined the accident has been caused by the jeep in question based on the investigation report filed by the police, mentioning that when they seized the jeep after 1 month, the the jeep bore a scratch on the mudguard of the tire on the upper footboard on the left side. The tribunal also relied on the charge sheet exhibit 1 filed by the police, wherein it has been stated that the accident was caused by the jeep in question on the basis of statements made by the appellant and other witnesses. The tribunal held that there was no reason to disagree with the conclusion of the police. In short, the tribunal disbelieved the evidence of the appellant's witness regarding the commission of accident by the jeep in question as unreliable, but nevertheless relied upon the investigation report as also the charge sheet filed with the police in that regard, which was
So, sir, all the
supported by
discussion-
two witnesses.
all the
One submission.
discussion-
I'll come to that. This finding was reversed by the Honorable High Court.
That is
Supreme
correct. Where is the
Then
finding?
matter was taken to Supreme Court.
Yes, where
The
is the
Supreme-
finding of that Supreme Court?
Supreme Court, just I'll come there. After referring to earlier judgments, yes, page number 669, para 23. Following the enunciation of Bimla Devi's case, this court in Parmeshwari versus Amir Chand noted that when filing of the complaint was not disputed, the decision of the tribunal ought to have been reversed by the High Court on the ground that nobody came from the office of SSP to the complaint. That's one thing.
These are all the judgments cited there.
No. Cited judgment. Thereafter, the finding is also there. Para 626.
Yes.
In the above conspectus, the appellant is justified in contending that the High Court committed manifest error in reversing the holistic view of the tribunal in reference to statement of witnesses forming part of the charge sheet. FIR Jeep seizure report in particular to hold that Jeep number RST 4701 driven by respondent was involved in the accident in question. Indeed, the High Court was impressed by the mechanical investigation report exhibit 5, which stated that only a scratch mark on the mudguard of the left tire of the vehicle had been noted. On that basis, the proceeded to observe that the same was in contradiction of the claim of the appellant claimant, ruling out the possibility of involvement of the vehicle in the accident. This conclusion is based on surmises and conjectures, and also in disregard to the relevant facts of the vehicle. Vehicle was seized by the police after investigation only after 1 month from the date of the accident, and the possibility of the same having been impaired in the meantime could not be ruled out. In other words, the reasons which were the High Court for reversing the finding of fact recorded by the tribunal upon holistic analysis of the entire evidence about the involvement of Jeep number RST 4701 in the accident cannot be contentionated. For those reasons, do not affect the other overwhelming circumstances and evidence which has come on record, and commended the tribunal about the involvement of the subject Jeep in the accident in question. This being the main edifice for which the High Court allowed the appeal referred by respondent 2 and 3, it must necessarily follow that the finding of fact recorded by tribunal on the factum of involvement of Jeep number so and so in the accident in question will have to be restored for reasons noted therein. Then again, this one, another judgment. 2009-13 Supreme Court case, that is Bimla Devi, that is referred to here in this case. I need not, I think, suffer. That has been reiterated there. Sunita Devi, that is 2020-13 Supreme Court cases 486.
If any judgments are else there, you can pass one at a time and you can refer to that.
So I thought it,
Yes. Which para?
one second, madam. Para number 21 to 28. We have no hesitation in observing that such a hyper-technical and trivial approach of the High Court cannot be sustained in a case where here also the claim petition was rejected by the High Court. Sustained in case of compensation under the Act in connection with the motor vehicle accident resulting in the death of a family member. Recently in Mangalaram versus Oriental Insurance Company Limited, to which one of us, Kanvilkar J, was a party, this court has stated the position as to the approach to be adopted in accident claim cases. In that case, the court was dealing with a case of an accident between motorcycle and a jeep, where the tribunal had ruled upon the FIR and charge sheet, as well as the accompanying statements of the complainants and witnesses to opine that the police records confirmed the occurrence of an accident and also the identity of the offending jeep. But the High Court had overturned the finding inter-alia on the ground that the oral evidence supporting such finding had been discarded by the tribunal itself, and the reliance solely on the document forming part of police
I've
report.
seen that. I've seen that.
Yes, Your Lordship.
I'll record
And,
that.
and para number 22
Yes, I've seen all the paragraphs.
and 27.
You have marked it, I've seen.
Yes,
Please
yes.
come.
One judgment, Your Lordship, with regard to the, which I said that what the stand when the such a plea is taken by the respondent, either insurance company or the one or whoever maybe. What could be their attitude in
Yes, pass on that also.
Yes, that statement also. That is, of course, Madras High Court judgment. That is in page numbers.
Yes, pass on.
This is page number 15. Sorry, para number 15.
Yes.
It is true that the first information report, there was no mention about the description of the private bus or registration number of number or any other particulars. However, on 24/12/2010, that is 5 days after the accident on Saravanan was produced by his brother Subramanian before the Gindis police station and admitted his guilt. According to the insurance company, the said Shivaraman colluded with the claimants to get compensation, and therefore he voluntarily surrendered before the Gindi police station. If it is so, the court is at loss to understand as to why insurance company did not examine the so-called Saravanan in this case. When the insurance company comes forward with such a defense and the said Saravanan was implanted by the claimants, the burden is heavy on its burden to show that the bus in question was not involved in the accident which caused the death of the deceased, or it was not driven by the accused Saravanan in the place where the deceased died. To substantiate the defense raised by them, the insurance company ought to have examined Saravanan or the owner of the bus as a witness, and they will be the best person to say as to whether Saravanan was employed by Praveen Travels as driver, whether the bus proceeded on the place of accident on this case on 19/12/2010, or whether the bus was insured with the respondent.
Yes, I've seen that.
And then, my lord, para number 16 further, just that also I have marked it. Wherein
Yes,
court
yes, I'll
says,
record that.
thus the burden, thus the initial burden on the part of the claimants
They're all
has been
settled
discharged
law.
by producing.
No, it's all
No, my lord,
settled law.
my lord, I am saying, my lord, yes, your lordship has, if it is decided that the claim petition is to be, dismissal of claim petition to be confirmed. Alternatively, I am asked for the, if it is remanded, I will get an opportunity to substantiate through eyewitnesses.
Yes,
That I am making a submission. That submission also I am making.
yes, I'll record that also. Agreed with the orders passed in MVC number, agreed with the dismissal of MVC number 3916 of 2011 dated 12th April 2013. The claimant is before this court. The claim petition is filed seeking compensation of an amount of rupees 10 lakhs for the injuries sustained by the claimant in the accident. The facts of the case are on 4/8/2010 at about 10:30 a.m. when the claimant was going on a motorcycle. It's a pillion rider. The rider of the motorcycle rode the same in a high speed in a rash and negligent manner and dashed against the motorcycle on which the petitioner is traveling, due to which the claimant is traveling, due to which the claimant fell down and had sustained simple as well as grievous injuries and had suffered pain and agony and financial loss. The tribunal, by order impugned, had dismissed the application filed by the claimant seeking compensation and is one under Section 166 of the Motor Vehicles Act. So coming to such a conclusion, the findings of the court are that that on behalf of the claimant, he had examined PW1 to PW4, Exhibit P1 to P22 were marked. On behalf of the respondents, RW1 was examined, Exhibit R1 to R6 is marked. In the medical documents, in the discharge summary, it is stated, it is recorded that the claimant had fell from a two-wheeler after being struck down by a four-wheeler. It is the observation of the court that when his own document says that a four-wheeler is involved in the vehicle and that there is a delay of 3 days in giving the complaint, that shows that this vehicle is implicated in the case for the purpose of claiming the compensation. The court has come to the conclusion that the claimant has failed to prove that the accident had happened because of the involvement of the offending vehicle as stated in the petition, which is a two-wheeler, when the vehicle as per the medical records is involved as a four-wheeler, and accordingly dismiss the petition. Learned counsel appearing for the appellant claimant submits that in Exhibit P16 is the initial document which does not speak about or refer to any four-wheeler. It only says about fall from two-wheeler after being struck down. And after that, on all the documents, it is shown that about the involvement of a four-wheeler. Thereafter, there is no, he submits that, in fact, the court had, in fact, the police have registered a crime against the offending vehicle and the driver and the insurer, and after conducting a full-fledged investigation, the charge sheet is also filed. It is a contention of the learned counsel that in these, in claims of this nature, where application is filed seeking compensation, the burden of proof is on preponderance of probability, but not beyond reasonable doubt. It is submitted that when the insurance company is asserting a particular aspect, the burden lies on the insurance company to prove the same. And when they fail to prove the same, the court cannot. He relied on certain judgments, wherein the apex court has observed that reversing the said finding by the High Court was erroneous. He had relied on the judgment of the apex court in Mangalram versus Oriental Insurance Company Limited and others, reported in 2018, 5 SEC 656, and also the judgment of the Madras High Court in Wahida Banu and others versus Praveen Travels Private Limited and others, reported in 2023 ACJ 661. He had relied on the judgment of the apex court in Sunita and others versus Rajasthan State Road Transport Corporation, reported in 2020 13 SEC 486. Another judgment the council relied on is Janaba and others versus ICICI Lombard General Insurance Company, reported in 2022 ACJ 2003. He relied on in Sunita and others, he relied on paragraph number 21, paragraph number 22, 27, and 25, 27, and 28. Relying on these judgments, learned counsel for the claimant submits that the court had failed to consider the evidence in its proper perspective, and uh, in fact, the court has cast upon the burden on the claimant when for proving the things which are asserted by the insurance company. It is submitted that if the matter is remanded and an opportunity is given to the claimant, he would examine the witnesses in support of their case. So he submits that the dismissal of the claim petition by the tribunal is contrary to law and contrary to the evidence on record, and as such the order needs to be set aside and the matter may be remanded back to the trial court for fresh consideration. Next para, learned counsel appearing for the insurance company submits that the court had rightly dismissed the petition. It is submitted that when the claimant, when the claim petition is filed under 166, the burden lies on the claimant, which the claimant has failed to discharge, and there are no grounds to interfere with the well-considered order passed by the tribunal. Next para, having heard the counsels on either side, there is a material on record. This petition is filed seeking compensation under 166 of the Motor Vehicles Act. The accident had taken place on 4/8/2010. The complaint is given on 7/8/2010 after 3 days from the date of accident. The medical records plays a significant role in these claims, as immediately after the accident, the claimant was taken to the hospital, and the MLC register and other documents, how the accident had taken place will be recorded. Except Exhibit P16, all the documents show that it was hit by a four-wheeler. The court had considered those documents which are filed by the claimant, and the cross-examination, the chief examination, and how it was elicited from the claimant with regard to these, with regard to the entries in the medical register. And if the complaint is given on the same day, the things would have been altogether different. But in this case, the complaint is given after 3 days. 3 days. And now the vehicle that is involved in the accident is a two-wheeler. There the discrepancy between the medical and the police records. As the claimant had placed before the court all those documents, he cannot ask the court to partly rely on those documents and partly, no, only to rely on those documents partly. The court has to, when once a document is marked, the court has to consider the entire document. Though now in this case, the burden lies on the claimant in the light of the documents that are produced by him, that there is a discrepancy in the medical documents, and he should have examined somebody to elicit the truth or otherwise of the said document. Admittedly, he has not. Admittedly, he has not examined anyone. Then coming to what is whether it is preponderance of probability or beyond reasonable doubt, there is no dispute on the proposition that in these matters the burden has to be proved on the touchstone of preponderance of probability. But in a case where basing on the documents that are placed by the claimant himself, now the claimant cannot say that the burden lies on the insurance company to prove. In those circumstances, the court had rightly held that the court had rightly held that the claimant had failed to prove the accident. And in the facts and circumstances of this nature, the court alone cannot look at the police documents and a complaint that is given 3 days after the accident. In each and every case, giving a complaint belatedly would not affect the case, but all depends upon the facts and circumstances of each case. In this case, under these facts and circumstances, it will have an impact on the, it has an impact, and it will affect the case of the claimant. And court had rightly considered all these aspects. Then coming to the submission of the learned counsel with regard to remanding this matter, this accident has happened on 4/8/2010, and for the purpose of examining the doctors or the medical records or anybody and remanding the matter in 2025 will not serve any useful purpose, and this court finds no reason to remand the matter. Accordingly dismissed.
Cell number 6, O Mahesh for appellant. Chetan B.
Yes, Mr.
I
Mahesh.
appear for the appellant, my lord.
Yes.
Appeal by the insurance company and question of, my lord, the liability, non-involvement of the vehicle.
Please come to that paragraph.
Yes. Lord, you have to kindly turn to, my lord.
Yes.
Yes. Ink page 12, para 10.
Please read.
During the course of cross-examination, it has been elicited in detail with regard to the contents of the respective document and the suggestion denying the involvement as well as the rash and negligence of the driver of the auto has been denied. The suggestion about the negligence of the minor claimant also has been denied. It is the admission he has not witnessed the incident. The suggestion as per the defense of a second respondent has also been denied. In addition to that, the claimant has got filed affidavit of one Timme Gowda, son of Kapini Gowda, and the same is treated as evidence of PW2. In his evidence, the injured, that is the minor claimant, he is his relative and he has witnessed the incident. It is also the evidence immediately after the incident, he had shifted the injured to the government hospital CR Patna in the same offending vehicle, and as per the advice of the doctor, the injured was also shifted to government hospital Hassan and he was treated as inpatient. It is also evident the driver of the offending vehicle promised to bear the medical expenses, hence no complaint was registered at the first instance. During the course of cross-examination, it has been elicited in detail with regard to the nature, place of incident and the content of the respective document, and the suggestion denying the involvement as well as the rash and negligence of the driver of the MAP auto has been denied. The suggestion about the negligence of the minor has also been denied. The suggestion as per the defense of the second respondent has also been denied. Thereby, nothing has been elicited to dispute the involvement, rash and negligence of the driver of the auto. In spite of subjecting PW1 and 2 for cross-examination, PW1 and 2 are specific with regard to the contents of the police document. No fruitful cross-examination conducted to rebut the contents of the respective document. The evidence of PW and 2 correspond with the contents of the respective documents and also make it very clear with regard to the rash and negligent driving of the offending vehicle by its driver and for having registered a case in claim number 64 of 2011 for the offences punishable under section 279 and 337 of the IPC.
So the crime is registered.
Yes.
FIR, the charge sheet is filed, and what is
Yes.
evidence of confused by you. On basing on what you say, the vehicle is not involved in the accident or there is negligence on the part of the claimant.
The document, my lord, on behalf of the, my lord, the insurance company, RW1 has been examined
Yes,
and he has produced authorization letter, insurance policy and DL extract.
yes,
Now, my lord, I invite your lordship attention to, my lord, the wound certificate exhibit P6,
yes.
where, my lord, no vehicle number is forthcoming.
In all the wound certificates, vehicle number will be there.
Yes, my lord. They simply say RTA, that's all, nothing else. And
Yes.
P13 also may kindly be looked into, my lord.
Mm.
If the person who has witnessed the, my lord, the accident has taken this minor in the same auto, that is their case, and there are no, my lord, this thing for mentioning the, my lord, the type of vehicle and also number of the vehicle. P6 and P30, you will
Yes.
kindly see.
Yes.
Vehicle numbers are not forthcoming.
Mm. Yes.
Here. Lord, the accident is said to be on 25/4/2011 at 4:30 p.m. and the complaint, my lord, is recorded by a police constable subsequently on 28/4/2011 at 6:30 p.m. in the hospital.
Yes. Yes.
Then you have to kindly see these documents, and moreover, my lord, the complaint is not given by PW2, said to be the eyewitness.
Mm.
And it is only the complaint that was recorded, my lord, by the police constable in the hospital
Yes.
on 28/4/2011 at 6:30 p.m. Date of accident is 25/4/2011.
Yes.
Under these circumstances, my lord, you must kindly see exhibit P6 and P30. They do not disclose either the type of the vehicle or the registration number of the vehicle.
Yes.
Yes. Therefore, my lord, the finding of the tribunal that the insured vehicle has been involved and caused the accident is not proper
Yes.
and correct, has to be the thing. Then, my lord, the next defense taken by the insurance company that the insured himself was driving and he had no valid driving license.
Yes.
Exhibit R3 was produced. He was issued with the, my lord, license for non-transport vehicle.
Yes.
Yes. Therefore, my lord, the insured vehicle said to be the, my lord, the transport vehicle. He had no authorization to drive a transport vehicle.
Yes.
Exhibit, my lord, R3 may kindly be looked into.
Yes.
Yes. So on these two counts, my lord, the insurance company would not be liable.
Yes. Come. Agreed with the
And
word part. Yes.
that's all, my lord. I think.
Agreed with the word passed in MBC number 89 of 2011 dated 18th July 2013. The insurance company is before this court questioning the liability of the insurance company, questioning the liability. It is a case of the claimant that on 25/4/2011 at about 4:30 p.m. the claimant was proceeding. Here, the regard at the time the driver of the auto rickshaw driving registration number, driver of the auto rickshaw do the same in a rash and negligent manner and dashed against the claimant, as a result of which it sustained grievous injuries. Immediately, he was shifted to the government hospital in the very same auto and undergone surgery and treated as inpatient and spent sufficient amount towards medical and other incidental expenses. The tribunal had come to the conclusion that the accident had happened because of the rash and negligent driving of the driver of the offending vehicle and granted compensation of an amount of rupees 1,80,000 Then counsel appearing for the insurance company submits that the the vehicle is not it was not established that the vehicle is involved and the accident has happened because of the rash and negligent driving of the driver of the offending vehicle. It is submitted that exhibit P6 and exhibit P13, that is the copy of the wound certificate and the copy of the MLC register, do not contain the auto number. And further, the accident has happened on 24/4/2011 and the complaint is given on 28/4/2011. The police have recorded the evidence, registered the complaint on 28/4/2011. It is submitted that all these things shows that the involvement of the vehicle, there is no involvement of the vehicle. It is submitted that the driver of the offending vehicle is having the license to drive the non-transport vehicle, and the vehicle that is involved in this case is admittedly a transport vehicle. As such, on both on these counts, the insurance company is not liable to pay the compensation. Next para. And counsel appearing for the claimant submits that the court had rightly considered the evidence and rightly granted the compensation, and no grounds are made out seeking interference with the well-considered order. Next para. Having heard the counsels on either side, there is a material on record. The accident had taken place on 24/4/2011. He was hospitalized. He was taken to the hospital, according to him, in the very same auto. And the police have recorded the statement. Police have registered the complaint and after a full-fledged investigation had filed the charge sheet. It is the contention of the insurance company that exhibit P6 and P13 do not contain the number of the vehicle as if the said vehicle is not involved in the accident. That contention this court is not able to accept. Not necessarily in all the cases that the medical records will contain the vehicle numbers. Further, the police records and the medical records are consistent, and a charge sheet is filed. And this court finds no reason, no force in the argument of the land counsel for the insurance company. Then coming to the non-transport and transport vehicle, in the light of the law laid down in Mukund Devgan's case, Mukund Devgan and so and so, still the insurance company is liable to pay the compensation in view of the same. In the light of the above discussion, this court finds no reasons to interfere. Accordingly dismissed.
Cell number
Yes, next.
7, SP Hikram Hulkan for appellant.
For the appellant, of the insurance companies, affiliate of the insurance company, on the question of
Amount in deposit to be transferred. Amount in
Yes.
deposit.
All that amount in deposit to be transmitted in all these appeals of the insurance company. Yes.
my lord, on the question of false implication, my lord, your lords may kindly appreciate from the page 10, last two lines of the discussion commences. Beforehand, my lord, this accident took after 4 days. My lord, the complaint has been lodged. My
Where
lord,
are you
the-
reading?
Pardon, my lord?
Where the court has to look at.
My lord,
Which page?
paragraph, page 10, my lord, last two line onwards, my lord, the discussion commences. My lord, our contention was, my lord,
We'll read.
yes,
Paragraph 15.
on going through, my lord, you pay paragraph 15, on the last two lines,
No,
on
read
going
from the
through
beginning.
on going through the above documents and the charge sheet exhibit P18, it reveals the complaint of the petitioner. Police have investigated the matter and have placed a charge sheet against the driver of the motorcycle bearing so and so for having caused the accident due to his rash and negligent riding and causing grievous injuries to the petitioner. Even though the respondent number 1 has contended that the accident has occurred when the petitioner himself was riding the scooter and while going near Kodava Samaja, it was raining and due to poor visibility, his scooter got skidded and he sustained injury. But the charge sheet was placed against a rider of the motorcycle wearing so and so. Clearly disclosed that after causing the accident, the motorcycle rider himself had taken the petitioner to the hospital and after admitting him, he has escaped along with the motorcycle. The act of the respondent number 1 clearly goes to show that he had caused the accident. He had got admitted to the petitioner to the hospital for treatment and thereafter he got absconded. Second respondent, even though contend there was a delay of 4 days in lodging the complaint, the petitioner cannot be blamed for it as he was admitted to the hospital and police have recorded his statement in the presence of the doctor on 11/5/2012. As the petitioner was admitted to the hospital, it was for the hospital authority to send the information to the concerned police regarding the
I've
medical.
seen, what are your submissions?
My submission is, my lord, the accident took place on 8/5/2012, and my lord, the complaint was lodged on my lord 11/5/2012. After
The
4 days,
observation of the court on that are satisfactory.
my lord, my humble submission for that only, my lord. My humble submission is, my lord, the petitioner was, my lord, said to have been accompanied with a pillion rider. At the earliest point of time, my lord, either the pillion rider, who is the co-brother of the petitioner, and also the hospital authorities, they were not informed. And after 4 days, my lord, they hatched a conference.
If the hospital authorities have not informed, having known that it is a medico, it's an
Yes, my lord,
emergency,
that's
why
our
not?
contention.
For
And
that we can't find fault with the claimant.
no, my humble submission is, your lordship may kindly appreciate,
Yes.
the rider of the motorcycle has been examined before the tribunal. What he says, my lord, he was parked his vehicle near that place. At that time, my lord, it was heavily raining, and my lord, the petitioner riding this scooter, my lord, because of this rain, skidded on the road, my lord. And
Said so.
pardon, my lord,
Who said that?
the rider of the motorcycle, RW2. And then, my lord, he says, my lord, he has given evidence before the tribunal. And my lord, he says, my lord, that on humanitarian ground, he removed to the hospital, helped the petitioner for removing him to the hospital. My lord, afterwards, my lord, the charge sheet has been filed against the rider of the motorcycle. So my humble submission is, my lord, your lords may kindly see the facts and surrounding circumstances. Simply because charge sheet has been filed, my lord, this vehicle is not involved. But if the rider of the motorcycle remained absent, then it was entirely a different story. And he appeared before the tribunal and gave evidence. In such circumstances, my lord, to rebut this contention, my lord, the petitioner could have examined, my lord, one hospital authority, or else, my lord, the rider of the motorcycle itself. And surprisingly, your lords may kindly see, rider of the motorcycle, as per the admission of the petitioner himself, he sustained no injuries in the accident. And their contention was, this vehicle, our vehicle, dashed against the hind portion of his motorcycle. And apart from this, my lord, the police, the concerned RTO has been, my lord, it was subjected to this IME report, my lord. And in the IME report, it was found that, my lord, no visible damages. My lord, this clearly indicates there is no reason for after 4 days filing of complaint. So this clearly indicates, my lord, at least he could have examined the rider of the motorcycle. Nothing prevented him from examining. So if he
Who is the rider of the motorcycle?
rider of the motorcycle, petitioner himself. And he had a, my lord, this pillion rider was accompanied. He could have examined him because he is one of the eyewitness to the accident. And on our part, my lord, we have examined our rider of the motorcycle.
Please come. Agreed with the orders passed unanimously.
For enhancement, one more appeal is there.
7.1 is there. Yes, please come to that.
Hello.
Come to that.
He is working as a, my lord, supervisor, helper, my lord.
Come to the table.
Page number,
Paragraph, my lord, 20, my lord.
para 22, my lord. Petitioner has contended that.
What are the injuries?
Injuries, my lord, he sustained fracture of both bones of left forearm, my lord, and surgery was done. And as per
So
the
pain
evidence
and
of doctor,
suffering,
my lord,
pain and suffering will get 40,000. How many days he was in hospital?
7 days.
Seven days.
Yes.
7,000. Then what is the income according to you?
Income, my lord, 4,500 was considered, my lord.
Which year is the accident?
Accident of the year, my lord, 2012.
12, my lord.
2000?
2012.
12,000.
Considered the disability at 6% to the whole body, my lord. As per the evidence of the doctor, my lord, the 40% to the particular
No,
upper leg.
medical expenses, there is no dispute.
Yes.
What is the disability according to the doctor?
Doctor, my lord, 14% is said, my lord, but
No, no.
considered 6%.
Whole body,
Whole body is 14%.
1/4.
1/4.
And to the whole body, how much is taken?
6%.
And then that needs no interference. What is the multiplier?
Multiplier, my lord, 13.
My lord, beforehand, my lord, may I
13.
read, my lord? Because the evidence of the doctor shows that, my lord, earlier he has suffered, my lord, he met with an accident and suffered injuries to
You're
the,
only on the quantum. You're
only on,
the
regarding
liability.
quantum only, regarding,
You're only on the liability.
I'm on the liability, but to determine the compensation, my lord, it is my duty to submit, my lord. As per the finding of the tribunal, my lord, he suffered injuries in another accident also. Paragraph 18, your lords may kindly look at.
Please read.
Page 15, my lord.
Hmm.
Petitioner got examined Dr. Bopanna as PW2, who has given affidavit evidence that he has examined the petitioner for assessment of disability and considering the pain and stiffness of elbow, swelling of the limb and difficult to lift heavy objects. He has assessed his disability 40% to the right upper limb.
That's why court had not taken only 6%.
That's what I am saying.
I'm saying I'm
Now
not.
he is saying that, my lord, 14%.
Court is not going to enhance it. That's what I'm saying.
Only that much. My lord.
Yes. What is the multiplier?
13.
Future medical expenses, how much the doctor said?
Lord, 10,000 is awarded by the tribunal.
Doctor.
Doctor, my lord, 15,000. 15,000.
Doctor said 15,000.
15.
It comes to 2,32,520. What is granted?
1,43,990.
1 lakh?
44,000.
43,995.
Rounded up to 1,44,000.
1,44,000. Please come. Agreed with the award passed in MBC number 3394 of 2012, dated 9 September 2013. Both the claimant and insurance company are before this court. The claimant's appeal is MFA number 924 of 2014, and the insurance company's appeal is MFA number 2738 of 2014. The claim petition is filed seeking compensation of an amount of rupees, one, how much?
1,44,000. Claim.
1,44,000 total amount.
Claim.
What is the claimed compensation? Claimed compensation of an amount
6
of
lakhs.
6 lakhs for the injuries sustained by the claimant in the road traffic accident. It is a case of the claimant that on say 8/5/2012 at about 5 p.m. when the claimant was riding the Activa on the extreme left side of the road. At that time, the rider of the motor offending vehicle came from the same direction in a high speed, in a rash and negligent manner, and dashed against the claimant's vehicle. Due to that, he fell down and sustained injuries. Immediately was shifted to the Jeon Hospital and he underwent operation for the fracture of left forearm. Plates and screws were inserted and he spent huge amount. As per the evidence of the doctor, he had sustained 40% disability to the limb and 14% to the whole body. Court had taken 18% to the whole body. No, the 40% to the limb. The court, considering the fact that he has earlier suffered injuries and also he has sustained disability, court had taken 6% as a disability and granted the compensation as per the table given below. Table is at page 22, extracted, para 28. Land counsel appearing for the insurance company submits that they've examined the driver of the rider of the offending vehicle who has reposed that the claimant had fell down due to the as it was raining on that day on humanitarian grounds. He had admitted him in the hospital. Land counsel for the insurance company submits that when there is a pillion rider who is his co-brother, the claimant had not examined him and he has not discharged the burden cast upon him to show that the accident had taken place because of the rash and negligent driving of the driver of the offending vehicle. It is submitted that just because the FIR is registered and the charge sheet is filed, basing on that, the court cannot come to the conclusion that the accident has taken place because of the negligent driving of the rider of the offending vehicle. It is submitted that the delay of 4 days was also not considered by the court while giving the complaint. Next, I submitted that without proving that there is rash and negligent driving on the part of the driver of the offending vehicle, court had granted the compensation and then same needs to be satisfied. Next, learned counsel appearing for the respondent submits that the court had rightly granted the compensation basing on the evidence. No, the court had rightly held that the insurance company is liable to pay the compensation. He submits that when it comes to the compensation, the court had not granted just and reasonable compensation. The accident has happened in the year 2012 and the court had taken 4,500, which is on the lower side. It is submitted that on all counts, the compensation that is awarded by the tribunal is not a well considered one. Next, having heard the counsels on either side, there is a material on record. First, coming to the liability aspect, there is no dispute about the fact that he was admitted in the hospital and immediately after the incident, he was shifted to the hospital and he was taken to the hospital by respondent number by the rider of the vehicle, rider of the offending vehicle. According to the rider of the vehicle, he has taken him on humanitarian grounds, and the police have registered the complaint after 4 days. When this particular contention with regard to the delay, the trial court had rightly answered that when the patient was admitted in the hospital, just because there is a delay on the part of the police or on the part of the hospital authorities, the court cannot fasten the same on the claimant and cannot disentitle him from claiming the compensation. The contention that basing on RW1's evidence, the court had to based on RW1's contention and the report of the MV report that there are no damages. Even on this aspect also, court has rightly given a finding and this court finds no reasons to interfere. In view of the same, this court is of the view that the tribunal had rightly held that the accident had taken place because of the rash and negligent driving of the rider of the offending vehicle. Then coming to the compensation, this court had perused the compensation that is granted. Considering one fracture injury that is sustained by the claimant, this court is inclined to grant an amount of rupees 40,000 towards pain and suffering. Considering 7 days of hospitalization towards attendant transport and nutrition, this court is granting 7,000. Coming to the medical expenses, there is no dispute on that, and the court had rightly granted. Then the loss of future earning, the court had rightly taken 6% as a disability, considering the fact that The claimant had sustained injuries basing on the, in view of the earlier accident, earlier injuries. And coming to the income, considering the fact that this accident has happened in the year 2012, this court is taking 7,000 as income. For 3 months under the head of loss of income during the later period, this court is granting 21,000. To the loss of future earning, 7,000 into 12 into 13 into 6 per 100 is 65,420. Under the head of loss of amenities, this court is granting 20,000. Future medical expenses, doctor had deposed that he requires 15,000 and the court without any basis granted 10,000 and this court is granting 15,000. In the light of the law laid down in so and so 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 2,32,520. Appeal of the claimant is allowed by enhancing the compensation from 1,44,000 to 2,32,520. The appeal of the insurance company is dismissed. The amount in deposit shall be forthwith transferred to the trial court. Yes.
Number 8, Jagdish HT for appellant.
For the appellant in this case, claimant's appeal not seeking enhancement compensation.
Who appears? Where is Mr. Umesh?
B.S. Umesh.
I am here.
Yes.
And liability on the owner of the vehicle matter on the ground that the rider of the offending vehicle had not having a driving license to drive the vehicle the two-wheeler.
He has not taken that ground at all, in the appeal. I leave it to me.
That is okay, that we will see. Now, as far as that aspect is concerned, then the pay and recover will apply.
I leave it to me. But he has not taken that ground also.
That I'll record.
And
Like
case of injury,
it's a case of death or injury.
Injury case. Date of accident is 15/12/2006.
Please come to the table. Where is the table?
Page number 25.
How many are the injuries?
Only one injury. The fracture, comminuted fractures of
another 10,000 for pain and suffering.
The doctor assisted disability 27%.
2006 accident, 30,000 is 2006 accident.
Yes. Medical expenses?
28,000.
Yes.
The doctor assisted disability.
How many days he was in hospital?
7 days. 7 days. The PW2, the doctor assisted disability of 27% of the particular limb and 9% of the whole body.
Let's see, there is a discussion.
Kindly see. Para 14, page number 21.
Para number?
14, page number 21.
Yes.
The petitioner examined one doctor, H.V. Praveen, who deposed that there is a fractures of lefty lateral tibia condyle. The petitioner was operated with implants and the medical officer opined that there is a 27% of the limb and 9%.
There is a discussion about the disability.
And para 17, page number 24.
Yes, please read.
Okay. Added that the petitioner, even though choose the examined medical officer to prove the disability, but even as per the version of the doctor, there is only 9% of the disability. The wound certificate is petitioner indicates simple in fractures. It is neither compound or nor comminuted or no complication involved in the hack treatment. Documentary evidence related by the petitioner does not disclose any malunion or complication regarding post-treatment under these circumstances. I am the opinion that there is absence of conviction, expert evidence and background of the gravity of.
What is the evidence of the doctor?
The doctor, the assisted PW2, can you see PW2? The para 3, para 3. The X-ray is taken by the on 26/2013 shows that fracture united and implant institution evaluation as the partial permanent disability of 27% of that limb, which amounts to 9% of the whole body.
How it is?
As per the wound certificate, my kindly see. There is a grievous injury,
Yes, sir.
Grievous injury. The wound certificate shows that,
Doctor, on what basis he has come to that? That's a whole issue.
Please, the para 2, this necessity, I examined him on 26/2013. He has difficulty in bending knees, sitting, crossing, and squatting, climbing stairs. He has knee flexion up to the 80% secondary assessments on top of the left knee. This is Dr. Opin's Malata.
Pass on that.
Please. PW.
He says fractures are united.
But fractures are united, my lord.
Then what is the disability?
But the doctor says that 27% of the particular.
That's why court has not considered.
That is the reason, my lords.
Yes. Which year is the accident?
Like 2006, my lord, 15/12/2006. Like that.
According to you, what is your income?
Like that, 10,000 by, he was an agriculturist, my lord, by claiming 10,000. 2006.
Take 3,000.
Please. But as per the doctor says, not 27% yes.
Huh?
Doctor evidence says that, my lord, 27% is the left lower limb.
That is without any basis, court had rightly held. Comes to 85,000. Yes.
May I
Huh?
make one submission, my lord? He is a businessman, my lord. That is one of the reason. Para 16 may kindly be seen. I will leave it at that.
No document.
Para 16, the Supreme Court, one of the judgment of the High Court is also referred to. It comes to the conclusion that it does not come in the way of his.
Where is that?
My lord, para 16 may kindly be seen. He is a businessman and he is not in a position to do his regular work. Absolutely no clinching cogent evidence. My lord, at the bottom there is a judgment referred to.
Yes.
Now Melody is saying agriculturist.
Agreed with the order passed in MVC number 58 of 2010, dated 18th February 2014. The claimant is before this court seeking enhancement and also the questioning the liability. The tribunal had fastened the liability on the owner of the vehicle as the driver of the offending vehicle was not having a valid driving license. Then coming to the compensation, the court had granted the compensation as per the table given below. Land Council submits that when he had sustained severe injuries, the court had not granted a just and reasonable compensation. When it comes to the liability, it is submitted that even the claimant is a third party to the insurance policy. As such, even if there is no driving license, still the insurance company is liable to pay and record the same from the owner of the vehicle. It is submitted that the compensation, when the doctor had deposed that there is disability, court had not considered the same, and nothing has been granted on the head of loss of income during the later period, and the amount that is granted is not reasonable. Next parallel, and counsel appearing for the insurance company submits that the ground with regard to the no driving license and the liability of the insurance company, no such ground is taken by the claimant. Next. It is submitted that when it comes to the loss of income during the later period, court had given a finding with regard to the occupation that he is a businessman, and nothing has been placed on record to show that it had an impact on his the injuries had an impact on his earning. Further, it is submitted that court had rightly not granted the compensation, not consider the disability as per the evidence of the doctor, as the fractures are united and the evidence of the doctor was not considered in the light of the same. It is submitted that no enhancement is called for and the insurance company has no liability to pay the compensation. Next, having heard the land counsel on either side, where is the material on record? First, coming to the aspect of liability, it is that the insurance company, that the driver of the offending vehicle is not having a valid driving license. The contention of the insurance company that such a ground is not taken by the claimant has no legs to stand, as that is a legal ground which is available to the party and that can be raised at any time of the proceedings. In the light of the settled law in Swaran case, the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Next para, coming to the compensation, as far as not granting the compensation and not considering the disability, the tribunal had rightly passed the order This court had perused evidence of the doctor. In those circumstances, the court had rightly not granted the compensation. Then coming to the pain and suffering, considering the previous injury, this court is inclined to grant an amount of rupees 40,000. And towards medical expenses, no interference is called for. For the nourishment, transport, and other incidental expenses, considering the 7 days of hospitalization, this court is granting 7,000.
Milan,
The-
2000 accident, Milan, 2006 accident, 7,000. Milan,
was-
today, of course, 1,000 would be all right, but 2006, Milan.
Yes, the loss of income is concerned. The tribunal had rightly held that the tribunal has rightly held that he is not entitled for the loss of income during the laid up period. The light of the law laid down in so and so legal expenses 10,000. Altogether, the claimant is entitled for 76,000, and the claim amount is enhanced from 63,800 to 76,000. Accordingly, the appeal is partly allowed. Yes,
Published.
Number 9, consider R for appellant.
For appellant in this case.
Srinath.
Yes, who appears
Claimant
for the
appeal, my
respondent?
lord.
Appearing for the respondent number 1, my lords.
Yes,
Claimant appeal, my lord. Claim petition is dismissed.
on the ground.
On the ground that, my lord, the claimant failed to prove the involvement of the vehicle, and, my lord, on the basis of the, only on my submission is, my lord, the tribunal records these findings without there being any contrary evidence from the other side, and only on the basis of assumption and presumption, my lords. Para 12, my lords, page number 13.
First of all, with regard to the involvement of the vehicle, burden lies on you.
Please, I am proved, my lords.
How you proved? That's why please
Please.
come to that discussion.
Please, para 12, my lord, page number 13. One more submission, my lord. The respondent not denied the involvement of both the vehicles, my lords, in this
Let's
case.
see, let's see the finding first.
Please. In this case, it is the case of the petitioner, para 13, my lords, page number 33. That on 18/9/2011 at 7:30 p.m. he was going in a motorbike, and at that time power tiller was coming from the opposite direction in a rash manner with high speed, even without a minimum light, and dashed against the motorcycle. Though the police paper states that the accident was due to rash and negligent driving by the power tiller, however, it is very much common sense that the power tiller, which is a vehicle which is to be carried by person by walking, cannot move in such a speed so as to dash against a motorcycle, so as to cause grievous injuries to the rider of the motorcycle. The power tiller is such a vehicle which cannot go in a high speed even though any person drives the same, as it is only vehicle used for tilling the lands, and that cannot be used as a vehicle for transportation. Hence, there cannot be any high speed in the power tiller. Under such circumstances, the case of the petitioner that the power tiller, which was coming from the opposite direction in high speed, dashed against the
So
motorcycle.
the police records are against this.
Yes, against this vehicle only, on the ground that power tiller was moving at the time of accident without having any headlight. The accident is occurred in the 7:30 p.m. evening hours. The power tiller was moving without headlights. Hence, the charge sheet is filed against the driver of this power tiller.
Yes. What is this finding?
No, the finding is on the negligence. There is owner has appeared before the tribunal, and it has been specifically stated the power tiller was parked on the extreme left side of the road. It is that point of time the claimant who was riding the motorcycle along with 2 pillion riders in an inebriated state, they have come and hit the power tiller and sustained injuries.
He would say so many things. That
No,
would
no,
not
it
be
is
the basis.
from the records. It is not that.
No. First of all, what is this finding? If the power tiller cannot go in a speed manner and all, where is the occasion for the court to go give us that kind of findings?
The owner has stepped into witness box, examined himself as RW1, and stated that the power tiller was parked. And this
That is his evidence.
Yes.
Police records
Yes.
are showing that a case is registered against them.
And apart from this, the entire depositions and the other records from the criminal court have been placed before the tribunal, and the same were marked in from exhibit.
What those criminal records say?
The depositions of the various witnesses who have stated that the power tiller was parked on the extreme left side of the road.
What happened to those? Ultimately,
exhibit.
what happened to that case?
It was acquitted.
On
the ground that the power tiller is not involved in the accident. that the
Specific finding is given.
accident occurred on account of negligence on the part of the claimant who was riding the motorcycle. Kindly exhibit R1 may
That
be
is the
taken.
finding of the criminal court.
Yes, kindly exhibit R1 may be taken for a moment, my lords.
See that?
That is the sketch.
Not the sketch.
No,
What is
the sketch.
the criminal doc, you're saying about the criminal case and the findings, which is that marked as?
It is marked
That is
as
not marked.
exhibit
No judgment is marked before the tribunal.
R6 to R11.
So basing on what you're saying that he is acquitted?
The entire order sheet is produced, my lords. Exhibit R6.
No, there must be judgment. Order sheet.
I
won't
would
come.
download that judgment and produce it before the court.
No, it should
because-
have been. it
No,
should
no,
have been
I
marked.
just saw the records. The entire depositions are placed. And even the claimant himself says that, as admitted during the course of cross-examination, that the power tiller can proceed with a speed of about maximum 9 kilometers per hour. And he also says that the power tiller had a headlight. This is his admission during the course of cross-examination. The issue is on negligence. It is not on the involvement. The tribunal has given a finding that there was no negligence on the part of the power tiller, and the claimant being himself negligent, the claim petition is dismissed.
Appearing for the respondent argues that in the judgment of the criminal case registered against the first respondent was acquitted by holding that the accident was not due to his negligence, and the honorable magistrate has held that the three persons came in a motorcycle in drunken state and dashed against the power tiller.
Yes, my lords. It is on negligence. It's not on involvement.
Where are the other persons? There are three people.
No, only two people are moving.
There
in
is
the
other
motorcycle.
person.
Other person is the malad, is the pillar, sorry, is the malad, is walking on the road, malad. The tiller was coming without switching on the headlight. Yes.
You were traveling along with some other person?
Some other person.
Where are they?
I am examining him as a PW3, malads.
What did he say?
But he says in chief exam, but is not turned up for cross-examination, malad, since the evidence is discarded. I am examining the doctor, malad. For a moment, my statement was recorded in the hospital in the very same day or date of the accident, malad. I am in my complaint.
Here, no, what they say is, no, the involvement of the vehicle is not questioned. The question is, whose negligence the accident has happened.
Yes.
No, for that, the only basis are the criminal records. Only basis of the criminal records.
Charge sheet.
Criminal, whatever it is, I mean, the police records.
Yes.
So all the records are against you now.
Against?
You, the
No,
claimant.
malads. All the records against the driver of the tiller only, malads.
No, my lords. The records are placed.
Malads, I am examined before the
What
criminal.
do you say about this paragraph just now? I
Plus,
read?
without, that is what my submission, malad, without any basis, malad, no judgment is produced.
My lords,
that
my lords,
exhibit,
RW2,
take that exhibit.
page,
R6, R6,
page 161 and 162 of the records, my lords.
R6.
Page
That is their
161 and
defense in the
162.
criminal case.
Wherein which the prosecution witness have categorically deposed that there were three people on the motorcycle and all of them were in a drunken stupor, and it is he who took them to the hospital immediately after the accident. It is they who have come to the extreme left-hand side of the road and they have dashed the.
Court gives a finding that criminal court has acquitted, and this is a finding of the criminal court. Where from the court has got all that? That's what I'm asking you.
That is from the depositions of
From
the
the
witnesses.
deposition, there won't be any judgment. Judgment must be pronounced by the court.
Yes, that I don't see there. I would place it before the court. Tomorrow it can.
Placing before the court. If the court comes to the
My lords,
conclusion, there should be some material.
My lords,
to the
two
court.
things, my lords. He himself says that the claimant in his cross-examination, he has stated that he has seen the power tiller machine about 50 feet away from the
I'm
place of
not into
accident.
all that. Court gives a finding. This is the judgment of the criminal court. Basing on that, it has acquitted the accused and find fault with this person, with the claimant himself. In that case, there should have been some material before the court to took even observation. Basing on what? You cannot improve
No,
the case.
I presume probably the court
Not
might,
presume. Come
going
to
by the depositions of the various witnesses that were placed before the court.
Basing on the witnesses' depositions, can the court give a finding that the
Even
magistrate has held that
yes,
the three persons came in a motorbike. How
yes,
can,
that is based on the deposition of our, at page number 161 and
It can't be
162
that.
of the criminal record, my
can't
lords.
be that.
No, that-
Finding of the court is not deposition, sir. Finding of the court will be in the judgment. Unless and until the judgment is placed before the tribunal, what is the basis for the court to come to such conclusion is the question.
Yes, but even I didn't see the judgment
So,
of the criminal
This
court.
order needs to be set aside. Some finding without any evidence on record.
My lord, even otherwise, my lords.
No,
my
it's not otherwise. That's the
No,
whole
my
basis.
humble submission is, my lords,
The court cannot assume and presume things and write something in the order.
no, that is an appreciating the evidence
No,
by
the court
tendered by
is
the prosecution.
completely prejudiced, and under this, on basing on para 14, court can understand. Assuming that he is
Kindly, a
already acquitted.
sketch may be looked into for a moment, my lords. Kindly, my lords. Exhibit R1.
And where
No,
will
the
this
sketch,
where will this finding at para number 14 will go? Read it. That is contrary to the record. Which is the document?
it is an argument by the council, my
No,
lords.
not the
Para
argument by the
14,
council.
Para 14. Para 14 of the judgment,
Hmm.
the learned counsel, the learned advocate appearing for the respondent argues that
Court
in the
has
judgment.
accepted his statement.
No, the finding is,
No. Court has accepted that however it is well established principle of law that in a criminal case is not a criteria to decide about
my
the
lord, the
compensation.
finding is at para 16, my lords.
Yes.
In this, I would read, my lords, with your lordships kindly. In this case, it can be clearly held that since the power tiller is a small vehicle which cannot move fast, the story of the petitioner that power tiller coming in a high speed dashed against him cannot be acceptable. If at all the petitioner was not going in a high speed and there could not have been such severe damage to both vehicles as mentioned in the IMV report marked as Exhibit P4, there could not have been any such injuries to the petitioner. By this, it can be clearly held that the accident was due to rash and negligent driving of the motorcycle in which the petitioner was
What is
going.
the maximum speed that a power tiller can?
9 kilometers per hour.
Where is the
And
evidence?
that has been stated by
No
him
evidence
only.
at all.
No, it is stated by him in the course of cross-examination. Claimant says so.
Charge sheet is filed, my lord, the outcome of the charge sheet is the power tiller was moving without switching on the headlights.
No, he says
That is
there
the
was-
root cause of the accident, not the speed, my lord.
He also
The
says,
negligence, the root cause of the accident is the negligence, not the speed.
my lords, in his cross-examination, he
Where do
says
you get it in there?
there was a
Charge sheet.
headlight.
Read.
I will read the charge sheet.
That's in English?
It's Kannada,
Read.
please. ಭದ್ರಾವತಿ ಗ್ರಾಮಾಂತರ ಪೊಲೀಸ್ ಠಾಣಾ ಶರದ್ದಿನ ಕಮೀರನಾರಾಯಣಪುರ ಗ್ರಾಮದ ನರಸಿಂಹನಾಯ್ಡು ಕೋಳಿ ಫಾರಂ ಹತ್ತಿರ ದಿನಾಂಕ 18/9/21 ರಾತ್ರಿ 7:30 ಸಮಯದಲ್ಲಿ ಸಾಕ್ಷಿ 1 ಮತ್ತು 7 ಅವರು ತಮ್ಮ ಕೆ ಸೋನ್ಸೋ ಬೈಕ್ ವೈರಹೊಂಡ ಬೈಕ್ ನಲ್ಲಿ ಹೋಗುತ್ತಿರುವ ಕ್ರಮ ಸಂಖ್ಯೆ 12 ಕಂಡ ಆರೋಪಿಯು ತಮ್ಮ ಪವರ್ ಟಿಲ್ಲರ್ ಸೋನ್ಸೋ ಟಿಲ್ಲರ್ ಅನ್ನು ಕನಿಷ್ಠ ಬೆಳಕಿಲ್ಲದೆ ಚಲಾಯಿಸಿಕೊಂಡು ಬಂದು ಡಿಕ್ಕಿ ಹೊಡಿಸಿದ ಪರಿಣಾಮ ವಿತೌಟ್ ಮಿನಿಮಮ್ ಲೈಟ್ ಈ ಡ್ಯಾಶ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಮೋಟರ್ಸೈಕಲ್. That is his negligence. Accident was occurred. Not, my lord, police have alleged that, my lords, not due to his rashness, but his negligence, the accident is occurred.
My lords.
And my lord, there is no basis for the tribunal to record a finding that, my lord, he cannot move, my lords, more than 9 kilometers or 5 kilometers, my lord. The case of the insurance company is that, my lords, negligence due to negligence of the motorcycle. But in order to prove their defense, my lord, accept their evidence, they are not examined the IVO before the tribunal. Because IVO is filed the charge sheet against the rider of the tiller, power tiller.
My lords, the claimant during the course of his cross-examination, two things were elicited from his mouth. One thing is he says he has seen the power tiller machine 50 feet away, 50 feet away from the place of accident. Second thing is he says there was a headlight to the power tiller and there was enough light available at the place of accident.
Is it so?
Yes, he has said so in the cross-examination. And he
Yes.
also says he was not holding the driving license, motorcycle was not insured, and there were two other people along with him. All these things have come out in the cross-examination.
Why you didn't read that evidence?
I will read, my lord, in the motor vehicle case, no such admission is given. What my learned friend is referring in the criminal case admission, my chief examination in the criminal case, I clearly stated that my lord, his negligence only accident was occurred. They suggested that, my lord, because of my negligence accident, I am denied it.
In cross-examination, you have accepted.
I am not accepted, my lord. I am stated only, my lord. The power tillers,
Look
please,
at
please,
what did you say?
please. As I am denied that, my lords, I was carrying 3 persons and my negligence only accident is occurred. And another suggestion is that, my lord,
Read in Kannada.
I mean Kannada, my
So
lord.
that she'll have the
Please,
benefit.
I read the Kannada cross examination in the CC, my lords. May I read the chief examination also, ma'am?
No, you read
Not required.
Okay, please.
cross of PW1
Yes,
ನೋಡಿ
yes.
ಶಶಿಧರ್, not the criminal record, cross of PW1 ನೋಡಿ.
PW1.
ಹೌದು, cross of PW1 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ನನ್ನ ಊರು ಭದ್ರಾವತಿ ತಾಲೂಕಿನ ಕಮರಿ ನಾರಾಯಣಪುರ ಎಂದರೆ ಸರಿ. ನನ್ನ ಮತದಾರರ ಚೀಟಿಯಲ್ಲಿ ಅದೇ ವಿಳಾಸವನ್ನು, ಅದು PW1 ನೀವು ಮಾಡಿರೋದ ಓನರ್ ಮಾಡಿ?
ಇಬ್ಬರು ಮಾಡಿರೋದ್ರಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ.
ನಾನು ಚುನಾವಣೆಯಲ್ಲಿ ಸಮಯದಲ್ಲಿ ಅದೇ ವಿಳಾಸದಲ್ಲಿ ಮತ ಚಲಾಯಿಸುತ್ತೇನೆ. ನನ್ನ ಪಡಿತರ ಚೀಟಿ ಅದೇ ವಿಳಾಸದಲ್ಲಿ ಇರುತ್ತದೆ. ಸದರಿ ಪಡಿತರ ಚೀಟಿಯು ಮೇರೆಗೆ ಪಡಿತರ ಸಾಮಾನುಗಳನ್ನು ತೆಗೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಸದರಿ ವಿಳಾಸ ಸಂಬಂಧಿಸಿದಂತೆ ನಾನು ಕಳೆದ 20 ವರ್ಷಗಳ ಪಡಿತರ ಚೀಟಿಯನ್ನು ಹೊಂದಿರುತ್ತೇನೆ. ನಾನು ಪ್ರಯಾಣಿಸುತ್ತಿದ್ದ ವಾಹನ ಚಾಲಕ ಮತ್ತು ಮಾಲೀಕರನ್ನು ಈ ಪ್ರಕರಣದಲ್ಲಿ ಪಕ್ಷರನ್ನಾಗಿ ಮಾಡಿರುತ್ತೇನೆ. ನಾನು ಹೇಳುವಂತೆ ಒಂದನೇ ಎದುರುದಾರನಿಗೆ ಸಂಬಂಧಿಸಿದ ಪವರ್ ಟಿಲ್ಲರ್ ವಾಹನ ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಮಾನ್ಯವಾಗಿ ಪವರ್ ಟಿಲ್ಲರ್ನ ವೇಗ ಹೆಚ್ಚೆಂದರೆ 5 ಕಿಮಿ 9 ಕಿಮಿ ಎಂದರೆ ಸರಿ. ಪವರ್ ಟಿಲ್ಲರ್ ಇಂಜಿನ್ ಅನ್ನು ಒಬ್ಬ ವ್ಯಕ್ತಿ ಹಿಡಿದುಕೊಂಡು ಹೋಗಬೇಕೆಂದರೆ ಸರಿ. ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಎರಡನೇ ಪುಟದ 2ನೇ ಪ್ಯಾರಾದ 2ನೇ ಸಾಲಿನಲ್ಲಿ ಹೇಳಲಾದ ರಾಜ ಎನ್ನುವ ವ್ಯಕ್ತಿಯ ತಂದೆ ಹೆಸರು ಸುಂಕ ಬೋವಿ ಇದ್ದು ಆತನು ಸಹ ಕಮರಿ ನಾರಾಯಣಪುರದವರೇ. ಅದೇ ರೀತಿ ಬಾಬು ಮತ್ತು ಅಶೋಕ್ ಇವರ ತಂದೆಯ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದರೆ ಅವರಿಬ್ಬರು ಸಹ ಕಮರಿ ನಾರಾಯಣಪುರದವರು. ನಾನು ಶಿವಮೊಗ್ಗ ಆಸ್ಪತ್ರೆಗೆ ರಾತ್ರಿ 10 ಗಂಟೆಗೆ ಶಿವಮೊಗ್ಗ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿದ್ದೆ. ಸುಮಾರು 1 ಗಂಟೆಗಳ ಕಾಲ ಸದರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿದ್ದೆ. ನಂತರ ಮಣಿಪಾಲ್ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿರುತ್ತೇನೆ. ಶಿವಮೊಗ್ಗ ಆಸ್ಪತ್ರೆಗೆ ಚಿಕಿತ್ಸೆ ಪಡೆದು ಹೋದ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವ ವಾಹನ ಡಿಕ್ಕಿ ಅಂದರೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಮತ್ತು ಟಿಲ್ಲರ್ ವಿವರ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ನಾನು ಪ್ರಯಾಣಿಸಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಚಾಲಕನ ಲೈಸೆನ್ಸ್ ಇರಲಿಲ್ಲ. ಅದೇ ರೀತಿ ಸದರಿ ಮೋಟಾರ್ ಸೈಕಲ್ ವಿಮೆ ಸಹ ಇರಲಿಲ್ಲ. ಮುಂದುವರೆದು ಸಾಕ್ಷಿಯು ಈ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲವೆಂದು ನುಡಿಯುತ್ತಾರೆ. ವಿಮೆ ಇರುವ ಬಗ್ಗೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಮಾಲೀಕರಲ್ಲಿ ಕೇಳಿ ನೀಡಿಕೊಂಡಿಲ್ಲ. ಮತದಾರರು ಗುರುತಿನ ಚೀಟಿ ಮತ್ತು ಪಡಿತರ ಚೀಟಿಯಲ್ಲಿ ನನ್ನ ಹೆಸರು ಎಸ್ ರಾಜು ಎಂದು ಇರುತ್ತದೆ. ಮೆಡಿಕಲ್ ಬಿಲ್ಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ 6 ಮತ್ತು 12 ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ಹಾಜರುಪಡಿಸುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಭದ್ರಾವತಿಯಿಂದ ಮಣಿಪಾಲ್ಗೆ ಹೋಗಲು ಎಲ್ಲಾ ರೀತಿಯ ಬಸ್ಸಿನ ಸೌಕರ್ಯ ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ 18, 12, 15 ದಾಖಲೆಗಳಲ್ಲಿ ಯಾವ ತರಹದ ವಾಹನದಲ್ಲಿ ನಾನು ಪ್ರಯಾಣಿಸಿದ್ದನ್ನು ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಅಪಘಾತ ಕಿಲೋಮೀಟರ್ಗಳ ದೂರವನ್ನು ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾನು ಯಾವುದೇ ಸ್ವಂತ ಜಮೀನನ್ನು ಹೊಂದಿರುವುದಿಲ್ಲ. ನಾನು ಒಂದು ಜೊತೆ 2
ಕಿಲೋಮೀಟರ್. What did he read just now? What is it?
ಅವುಗಳಲ್ಲಿ ಕಿಲೋಮೀಟರ್ಗಳ ದೂರವನ್ನು ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ.
That means?
In exhibit 18 and exhibit 18 in the said document they are not mentioned about the kilometers. ನಾನು ಯಾವುದೇ ಸ್ವಂತ ಜಮೀನನ್ನು ಹೊಂದಿರುವುದಿಲ್ಲ. ನಾನು ಒಂದು ಜೊತೆ ಎತ್ತು 2 ಹಸುಗಳನ್ನು ಸಾಕಿಕೊಂಡಿರುತ್ತೇನೆ. ನಾನು ಸಾಲ ಮಾಡಿದ ಬಗ್ಗೆ ತೋರಿಸಲು ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುತ್ತೇನೆ. ನಾನು ಪ್ರಯಾಣಿಸಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್
pertaining to the conveyance, my lords. He says he has used transport to
4 ಜನರನ್ನು
commute going to
ಪಡಿತರ
different places
ಚೀಟಿಯನ್ನು
for his
ಆದಾಯ
medical
ಇಲ್ಲದ
treatment.
ಬಡವರಿಗೆ ಕೊಡುತ್ತಾರೆ ಎಂದು ಪಡಿತರ ಚೀಟಿಯಲ್ಲಿ ನನ್ನನ್ನು ಸೇರಿಸಿ 4 ಜನರನ್ನು ಹೆಸರನ್ನು ಕಾಣಿಸಲಾಗಿದೆ ಅವೆಂದರೆ ನನ್ನ ಹೆಂಡತಿ ಮತ್ತು 2 ಮಕ್ಕಳು. ಅಕ್ರಮವಾಗಿ ಪರಿಹಾರ ಪಡೆಯಲು ನಾನು ಸುಳ್ಳು ದೂರನ್ನು ನೀಡುತ್ತೇನೆ ಸರಿಯಲ್ಲ. ದೋಷಾರೋಪಣಾ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಲು ಪೊಲೀಸರು ನನ್ನ ಜೊತೆ ಶಾಮೀಲಾಗಿ ಸುಳ್ಳು ವರದಿಯನ್ನು ನೀಡಿ ಸುಳ್ಳು ದೋಷಾರೋಪಣಾ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಹೇಳುವಂತೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಯಾವುದೇ ಅಪಘಾತ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣಾ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಏನೆಲ್ಲ ಬರೆಯಲಾಗಿದೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಅವಿದ್ಯಾವಂತ. ಹೆಚ್ಚಿನ ಪರಿಹಾರ ಪಡೆಯಲು ಸುಳ್ಳು ರಸೀದಿಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ಹಾಜರುಪಡಿಸುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಚನ್ನಗಿರಿ ಪಟ್ಟಣದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬೈ ದಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ.
1 second. 2 things, my lords. One is he says the teller machine cannot be propelled on its own. It's a person has to hold it and pull it. That is one thing. Second thing, he also says that the maximum speed at which tiller machine can proceed is 5 kilometers per hour. And next, in the further cross-examination, he says that he has seen the vehicle 50 feet away from the place of accident. And he also sees there was an headlight to the tiller machine in the further cross-examination. That is a claimant.
What did he say? He saw it 50 meters away.
50 feet away from the place of accident, he has seen the vehicle and there was an headlight to the power tiller. And he also says it cannot be propelled on its own. That is a power tiller machine. Someone has to hold it and pull it, my lords. So and kindly, why I'm insisting, my lords, the exhibit R1 is the sketch. The sketch shows that the tiller machine is on the extreme left side of the road. The motorcycle which is coming from the opposite direction, he has gone to that extreme left side and he has dashed the power tiller machine, my lords. The sketch is very clear on that.
That's in the cross-examination, he specifically denies that, my lord.
No, 1 minute. Look at it and tell the court. Did you say that you have seen the light of that power
Not
tiller?
light, my lord.
It had a
In the
headlight.
cross-examination, he says that, my lords, ನಾನು ಪವರ್ ಟಿಲ್ಲರ್ ಅನ್ನು ಸುಮಾರು 50 ಅಡಿ ದೂರದಿಂದ ನೋಡಿರುತ್ತೇನೆ. From he says that, my lords, from 50 feet, he seen the power tiller, my lord. Is very impossible, my lord. One can see any vehicle from more than 50 feet, my lord.
That is your admission.
That is
What is
cross-examination. And then further cross-examination, he specifically denies ಪವರ್ ಟಿಲ್ಲರ್ ವಾಹನ ವೇಗವಾಗಿ ಓಡದ ಕಾರಣ ಇದರಿಂದ ಯಾವುದೇ ಅಪಘಾತವಾಗಿಲ್ಲ ಅಂದರೆ ಸರಿ.
ಅಲ್ಲ ಹೆಡ್ಲೈಟ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೆಡ್ಲೈಟ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ ಇದೆ ನೋಡಿ ಅಲ್ಲಿ.
ಆಯ್ತು ನೀವು ಓದ್ಬಿಡಿ.
ಇಲ್ಲ ನಾನು ನೋಡಿದ್ದೀನಿ.
During cross-examination, what he denied?
ಡಿನೈಡ್ ಮ್ಯಾಮ್ ಹೆಡ್ಲೈಟ್ ಇತ್ತು ಅನ್ನೋದು ಸರಿಯಲ್ಲ ಅಂತ ಡಿನೈ ಮಾಡ್ತದೆ ನೋಡಿ ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್.
No, he says ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ವಾಹನಕ್ಕೆ ಹೆಡ್ಲೈಟ್ ಇತ್ತು.
ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಕಂಟಿನ್ಯೂಡ್. ನನ್ನ ತಪ್ಪಿನಿಂದಲೇ
And nor he says there was no headlight to the I misread it. And he says there was an headlight to his vehicle and he has seen the vehicle 50 feet away from the place of accident.
What he says?
He says he has seen the power tiller 50 feet away from the place of accident and he also sees that there was a headlight to his motorcycle at the time of accident. And kindly exhibit R1 may be taken, my lords, because he has come to the extreme left hand side and he has hit the vehicle, my lords.
Please come. Agreed with the word passed in MVC number, agreed with the dismissal of MVC number 46 of 2012 dated 29 June 2015. The claimant is before this court. It's a case of the claimant that on 18/9/2011, he was proceeding towards Kudligere village on his Hero Honda motorcycle and about 7:30 p.m. when he came near the poultry of one Narasimha Naidu, a killer was coming from the opposite direction without having any headlight. The driver of the said vehicle drove the same in a rash and negligent manner with high speed without observing the traffic rules and regulation and hit the same to the motorcycle and caused the accident. The court had dismissed the claim petition, observing that in this case it can be clearly held that since a power tiller is a small vehicle which cannot move fast, the story of the petitioner that the power tiller coming in a high speed dash against him cannot be acceptable. If at all the petitioner was not going in the high speed, there could not have been such severe damage to both the vehicle as mentioned in the LMV report. It can be clearly held that the accident was due to the rash and as mentioned in the MV report marked as exhibit P4 and there could not have been any such injury to the claimants. By this, it can be clearly held that the accident was due to rash and negligent driving of the motorcycle in which the petitioner was going. And it also shows that the power tiller is not involved in the accident. And accordingly, the court had negated the contention of the claimant that there is rash and negligent driving of the driver of the tiller. The court also observes that the police have filed a charge sheet against the first respondent who caused the accident by driving the power tiller in rash and negligent manner with high speed. On perusal of the entire records and nature of the vehicle involved in the accident, it can be held that the accident was due to rash and negligent driving of the motorcycle by the claimant himself and not due to rash and negligent driving of the driver of the tiller. The court gives a finding that the power tiller is a small vehicle. It cannot be driven on the road itself. It should be run by holding it by a person who can walk with it and no person can sit on it. Such being the nature of the power tiller, the first respondent cannot drive the same in a rash and negligent manner. And accordingly, the court had dismissed the claim petition. Learned counsel appearing for the petitioner appellant claimant submits that court more on assumptions and presumptions as to dismiss the petition. He submits that it is his case that the power tiller is moving without any light, and the accident had occurred at 7:30 p.m. And because of that, the accident had taken place. It is submitted that the police have filed a charge sheet against the driver of the power tiller. In that case, the court he has discharged his burden, and the burden lies on the insurance company to prove that the accident had taken place on behalf of the negligence of the claimant, but not of the driver of the power tiller. It is submitted that the court, assuming and presuming the things, had dismissed the petition. He submits that the involvement of the vehicle is not in dispute. It is about the negligence, not having switching on the headlights at 7:30 p.m. amounts to negligence, and on that basis, the insurer of the power tiller is liable to pay the compensation. Next parallel, counsel appearing for the respondent
Number 2.
Insurance company submits that the exhibit R1 is a sketch which shows that the power tiller is on the extreme left side of the road, and the claimant, who is coming from the opposite road, has gone to the extreme left side and hit the vehicle. That itself shows that there is negligence on the part of the claimant. Further, in his cross-examination in the claim petition, in the instant case, he has deposed that he could see the tiller from 50 feet away, and it is stated that the tiller cannot move more than 5 kilometers, 9 kilometers speed per minute. Cannot move more than 9 kilometers speed. It is submitted that all these things clearly revolves that clearly shows that the claimant is at fault. It is submitted that even in the criminal case also, the accused is acquitted, and the court has given a finding that the accident had taken place because of the negligence on the part of the claimant. Next para. In reply to the same, land counsel submits that there is no judgment placed on record to make such a submission, and he denied the same. Next para. Having heard the counsels on either side, there is a material on record. The vehicle that is involved in this case is a power tiller. It is an admitted fact that it cannot move on its own. It has to be propelled by a person, and the court gives a finding that nobody can sit on that, and it has to be pulled, that it should be run by holding it by a person who can walk with it and no person can sit on it. And in that case, and when the claimant could see the vehicle, the power tiller 15 feet away from him, and when he can find it and saying that because the power, the lights are not there, the accident had taken place. That, the said admission in the evidence in the cross-examination and the case of the claimant are not going together. And in fact, they are contrary to the case of the claimant. Considering all these facts, the tribunal had rightly held that there is no negligence on the part of the tiller, and it is on the part of the claimant. And the submission that it is more on assumptions and presumptions has no legs to stand. And this court finds that there are no reasons to interfere.
Much
Accordingly
obliged.
dismissed.
Grateful, my lords.
Yes. Yes, next.
List number 2, serial number 1.
Here for appellate.
Vasudev Murthy.
Here.
Nagesh.
130.
Uh,
Passover one, I'm saying it's 130. Other side is not there.
Other side is not there. 3 times he has not appeared.
That's why
ma'am.
we'll pass orders at 2:30.
I will not be available for health issues.
Tomorrow or day after?
A day after.
Day after.
Yes.
At the request of learned counsel for the appellant. Next two,
Serial number 2, N. Gautam Raghunath.
Passover,
Yes, sir. Serial number 3, attend.
remaining afternoon.
Serial number 23.
This two, my lord. Serial number 37, my lord. I pray for a week's time, my lord.
Why?
Senior ಸ್ವಲ್ಪ inconvenience ಇದೆ, my lord. Kindly have it after a week's time.
There are no adjournments at 1:30. That's what you have to understand. You have to wait till now. Once you start, everybody will start.
My lord,
Yes.
week's time, my lord. At
You
least day
can,
after tomorrow.
you can wait and ask your colleague to be there, or you can be there. Not, now we will not do it.
Serial number 23, my lord, there was a direction. There is a discrepancy in arraying a party as an insurance company. Instead of Future General Insurance Company, it has mentioned as a Bajaj. And there is a direction by this court to correct the judgment and send it to this court.
What happened?
Whether it has been received or not, we don't.
What is it?
No, I think the letter from the registry is kept below. That is what we.
That is on 17/11/2023.
Please, my lord.
Letter is on 17/11/2023.
17/11/25.
Is it in 23?
No, my lord, what happened in
No,
this?
no. Is it in 23? Item number
The
20.
item number 23.
No, but as for the cause list, it shows 17/11/23 date.
The letter has come from.
No, addressed by the RG.
Oh, okay. Lord, there was an order by this honorable court on 10/11/21.
It has come, I think. It is by the, from the, it is there.
Register Court of Small Service.
You want adjournment that also?
I will not be available in the afternoon.
Day after tomorrow, that also.
Yes.
Correction ಏನ ಲೆಟರ್ ಬಂದಿದೆ. Priyanka GM.
Where were you?
My lords, in morning session, I was held up in civil court.
Are you ready?
Yes, my lords. My lords, one submission, my lords. In this appeal, I have not filed Okalat for R2, my lord. The reason is I'm appointed by court, my lords. But party signature is required for Okalat, right?
Not necessary. You're appointed by the court to assist the court as amicus curiae.
Yes.
So you can assist the court.
What
And legal services authority will pay your legal fees.
My lords, one more submission, my lords. I have received only memorandum of appeal copy, my lords. Kindly see the order dated 10/10/2023, my lords. The office was
10/10/2023. It has not come up after that. Give that.
No, my lords. In that order, the court is ordered. This honorable court is ordered copies to be served to respondent number 2, my lords. But they are not given entire memorandum of appeal copy, my lord, along with documents.
Sri O. Mahesh, this is order dated 10/2/2025. Then counsel for the appellant in both the appeals appears through video conference and submits that the legal aid counsel is not receiving the copies of appeal.
No, my lords. 10/10/2023, my lords.
This is I'm looking at the latest order. He
After
submitted
the-
that you are
after
not
the-
receiving the papers.
After that, they have served copy, my lords. Only it is memorandum of appeal copy, my lords, but not
10/2/2025.
Yes, ma'am.
You are talking about something in 23.
Earlier order, my lords. 10.
Where is Mr. Mahesh?
Omesh. Omesh, sir.
As directed by the court, my lord, copies are served, filed in the registry.
Only appeal copy, my lords, not entire
Only
documents.
copy of the appeal memo is the grounds is given to her.
But she is only entitled for the appeal memo. Then she has to look into the record and do it.
You can
Both
serve it
records-
on her. You can give her. She's appointed by the court.
But she has to take the court file and get it ready, my lord. Appeal memo,
We will remember this when you make the similar submission. The registry is directed to take from the registry.
Yes,
Is directed to go furnish the counsel for the legal aid counsel with a copy of the entire set of appeal memo in both the cases. Set of papers in the appeal in both the cases. List these matters on 15th of April. Be prepared on that day and please do represent. Yes.
Cell number 3, Omesh for appellant. Venkatesh R. Bhagat.
My lord, morning in this appeal, 163A is the claim petition, my lord. The question is, we are getting 20,000, my lord, but under section 163A, it is 40,000. My lord's observation is also there. May I pass the judgment, my lord?
Not 40,000 per month.
Not 40.
40,000 per annum. 20,000 per month will become how much per year?
8 to 12. 2,24,000.
This please come. Agreed with order passed in MBC number. This is
Please,
which
my
case? Agreed with order passed in MBC number 51 of 2020 date 24 January 2012. The insurance company is before this court. The claim petition is filed under section 163A, read with section 166 of the IMB Act, claiming compensation for the injuries sustained by the claimant in the motor accident. The facts of the case are the petition that on 17/5/2007 at about 7:30 p.m. when the claimant was traveling in an auto rickshaw driven with respondent number 1. driven with the, and the respondent number one drove it in a high speed in a rash and negligent manner. And due to that, he lost control and the said auto toppled with the side of the road. Due to that, he had suffered fracture of the right knee, left hand and heel, and he lost his conscience. Thereafter, he was taken to the hospital and he has undergone treatment. The tribunal had framed two issues with regard to the issue number one is whether the claimant proves that on 17/5/2008 at about 7:30 p.m. the respondent number one being the driver of the Bajaj auto rickshaw in which the claimant was traveling drove the same in a rash and negligent manner. Due to that, auto rickshaw capsized, an accident caused and he sustained injuries. Whether the claimant is entitled for the compensation, if so, for how much? With regard to the first issue, the court gives a finding that
Injured himself while driving the vehicle.
the court observes that on going through the entire oral as well as the documentary evidence produced by the claimant, it is clear that in relation to this accident, no complaint has been registered by the jurisdictional police station. But the claimant had lodged a private complaint on 4/3/2008, and when the court referred the case to the police station, on that basis, a crime has been registered, and thereafter, a B report has been submitted by the investigating officer, and the claimant has challenged the said B report by filing objections. And after recording the sworn statement of the claimant, cognizance was taken for the offences punishable under section 279 and 338 of IPC against the respondent number one. And summons have been served on the respondent who appeared before the court and obtained bail. Subsequently, the claimant did not appear before the court. Hence, the case filed with the claimant, criminal case filed with the claimant has been dismissed. The court also observes that the court has to see whether the accident caused due to negligence of the petitioner herein or due to the respondent number one herein. The court gives an the finding of the court is that the claimant failed to prove the rash and negligent driving of the respondent, and he had driven the said auto rickshaw at the moment of the accident. On the other hand, it is proved that the claimant himself drove the said vehicle and caused the accident. After that, suddenly the court jumps to the finding that this petition has been filed under section 163A of the MB Act and accordingly granted the compensation of an amount of rupees 3,08,800. When counsel appearing for the insurance company submits that the claimant had come to the court with suppression of facts and also played fraud on the court. When according to the claimant, he is earning 20,000. In that case, the annual income of the claimant is 6 lakhs per annum. Even on that count, he can't maintain an application under 163A. Further, coming to 160, if it has to be considered under 166, there has to be a finding, and the claimant has to establish that because of the rash and negligent driving of the driver of the vehicle, the accident had happened. In that, already tribunal has given a finding that the claimant could not prove the rash and negligence on the part of the offending vehicle. In view of the same, the tribunal went wrong in granting compensation to the claimant, and the same needs to be set aside. Then counsel appearing for the respondent claimant submits that just because it is the case of the claimant that is earning 20,000, court should not consider the same, and there is no evidence on record. It is her submission that unless there is evidence on record to show that his income is 20,000, then question of not considering the issue that whether the application under 163A is maintainable or not will arise. It is submitted that court had rightly considered all the issues and granted the compensation. There are no grounds to interfere. Next paragraph. Having heard the counsels on either side, so and so. The petition is filed as one stating that it is a petition under 163A, read with 166 of the IMB Act. If the same has to be treated under 163A, the income of the claimant shall not be above 40,000. 42 or 40?
41.
40,000 per annum. And once it is a case of the claimant that is earning an amount of rupees 20,000 per month, the argument of the land council that there is no material on record cannot be the ground, and even the claimant cannot be permitted to amend the pleadings or restrict the claim in the light of the law laid down by the Apex Court in Girish by, what is the judgment? Girish by in the light of the law laid down in Girish by something, the judgment is there. That takes it there. So and so.
United India, my lord. Girish by Sony versus United India Insurance
Girish by Sony versus United India
Insurance
Company reported in
AIR 24 SC 1 2107, my lord.
Take that. Give that judgment.
No, my lord. It is cited in another judgment.
That's what. Give it to her. So and so. Even they cannot restrict the claim in view of the restrict the same, and the trial court the tribunal went wrong in granting the compensation under section 163A, as the claimant is not entitled for compensation, and as rightly argued by the land counsel for the insurance company, under 166 also they are not entitled, as already court given a finding that the accident has the rash and negligence is in fact on the part of the claimant, and the claimant has failed to prove that there is negligence on the part of the driver of the offending vehicle, and that was not questioned by the claimant. In that view of the matter, the appeal of the insurance company is allowed, and the amount in deposit shall be forthwith transferred to the trial court, and the appellant insurance company is at liberty to withdraw. Yes.
List number 2, serial number 2, Gautam Raghunath, petitioner.
Yes.
Your
Lordship, this is the matter wherein even last week we had, it was only on that clause that was to be added. After that, Your Lordship, in fact, even this time, even after Your Lordship passed the order, child's not come. Child says, I'm tired, I'm not coming. If he messages the mother, the child messages him back, why are you messaging the mother? He does not come. Finally, counsel had to inform the other side counsel. After the complaint, then he messages and 2 months he's not seen the child act.
Yes, Pratima.
It's not there, huh?
Our only apprehension is we will sign all of this, and again, same thing.
You're not audible. Look at it. Is it muted?
Look, I'm sorry. I'm so sorry.
Yes.
Look, on 29th, what happened is the father got in touch with the child. Child said he's tired. The father left it at that. And then he messages the mother the next day. Then mother says, I will make my effort, and she made her effort, convinced somehow the child, and sends a message to the husband, you can come and pick up the child. Whereas he has already communicated to the child that I'm out of station, I'm going out of station. I don't understand what is the difficulty in the father either on that day if the child has said he's tired to come home and understand what is the problem, or next day to try. How he can just on 29th, if the child says I'm tired, he just goes off, Milots? There is messages exchanged between the parties where she's telling come and pick up the child, but he says I'm out of station, I've gone off to Nilgiris with my friends.
Yes. He's not gone ill with his friends, nor is there any such message. After the
There
child said
between
he's
the
not
parties
going
I
to
can
come, not
produce.
just on that day, even for the next days, he had meetings which had cancelled only for this visitation.
I
Since
can
she's
produce
not
the
sending,
messages.
he finally fixed up the meetings. I can even show
No,
proof
it
of
is
those
like this.
meetings.
It's all, it has to go on trust or what is going
Correct.
to
He's
happen.
told I don't trust you. Also, he has messaged
Consequences
me.
will follow. And now neither the court cannot constantly monitor what should
True,
happen
true.
between the father and the child.
And once this whole thing is signed and also done, not only she has all of those privileges and she just says, I'm not responsible, child says no, then we are left nowhere is
That is the
our.
first. That is the first
No,
misconception I think
all
the
this happened
parties
only
have.
after
Just
council was
because they are
informed.
saying, I do not
And
know
this is
what
not the first time.
privileges they
Last
are
3
talking
times we
about.
never
Lord.
trouble your lordship with all of these silly complaints at every point of time. He said this or he said that. We don't, because we're trying to close the matter. But for the last 2 months, not once has he even seen the child. So if they're trying to make an excuse of one day, that is after council informed their council, what
Which is
about
not
all the
true.
other previous times, your lordship? Your
Milas, which
lordship,
is
all
not
I
true.
want
I
to
think the
request is,
council
for
messaged me.
some time, let anyway now vacation, let custody be handed over for a brief moment. Let him at least spend some time and then they sign. We anyway want to sign and close this. But till such time, let at least the child come by and spend sufficient time. At least then they will also be convinced that signing this off and they will comply with all of these, your lordship. Otherwise, I'm quite certain the mother is not going to comply.
Milas,
We are
may I?
not doing any harm with. Sorry?
Milas,
They're
may
also
I
to
submit?
revert on that point, your lordship. Last time she took time saying that she will ask the wife and.
Yes.
Milas, may I submit?
Yes.
Whatever they are submitting is not the facts. I can produce the messages. Due to my ill health, I am not able to be present before the court. I'm extremely sorry.
Third apart, last occasion when the matter came up in the chambers, you said that you have to get instructions from her. What
Yes,
happened?
Milas. Yes, Milas. I thought there was only one clause which was in disagreement. Milas, if your lordships recollect, on 7th of February, this matter was listed. On 25th February, he was supposed to give a check or a DD for 50 lakhs. Thereafter, on 25th of April, the second installment was supposed to be given. Neither the council contacted me nor any terms were discussed. However, with efforts from my side, finally we met on 21st February in the High Court premises. And whatever was discussed is not changed in the memorandum of settlement. For that, I have to be before your lordships to even tell what are the terms that were discussed, Milos, and none of them finds a place. This I'm telling on record, including the remarriage clause, Milos. None of them have been changed. I thought it's only the remarriage clause that I have to discuss with my client. That is not the truth. Whatever was discussed with Mr. Gautam does not find the place. It is the same old thing that it has been shared with. But that's
Lordship,
not how
nothing
it is,
stops
Lord.
them from giving what they have to every
Let
time
me
she
just
wants them.
allow to
Because she
complete
wants,
because
let
I
her
don't
please
think
it,
I have
Lordship.
interrupted.
These
From
are
the
not
past
ways
1
to
year, the
hoodwink the
effort
court.
made by the council or the mother has never been appreciated. Father never had overnight for all these 10 years of the child's life. However, with great effort from the mother as well as me, I think he's been able to exercise overnight instead of having the trust or appreciating that. They only want to accuse the mother.
Ultimately, both the parties have to understand one thing. They are not doing any favor to the other.
Correct,
They are
Milos.
only doing things in their
Absolutely.
welfare.
I do
If the
understand.
matter settles, it is if the matter settles, it's good for the mother, it's good for the
Father,
father
yes,
and the
exactly.
child.
Yes, Milos.
So instead of both of you are asking for others' appreciation, both of you have to do something which is good for you.
Plus, all efforts are
No,
to see
only
that the
one thing I
matter
want to make it, no, I want to make it very clear. It's like enough time is given to both the wife and the husband and the child. No, things cannot go on like this. Court has so many other matters which are more important than again going back on the same issues. Now I'm making it very, very clear. If something works out by I'll list this matter on 8th of April. If anything works out, let it work out. And court is not even going to spend another minute on this case.
Definitely, my
I'm
lord.
very
All
clear on it.
efforts will be to
This
see
is
how this
matter
matter can be settled.
on 8th of April. By the time, if the parties are not, if they want to settle and they have to come up with the compromise, and if that's not, if there no compromise petition is filed before this court, signed by both the parties, the matter will be deleted from part third and will be posted for the regular hearing.
Grateful, my
Before
lord.
the
I'll make all my efforts, definitely.
Yes.
Your Lordship, might I request that same interim continue?
The interim, the arrangement with regard to the registration shall go on as ordered by the court earlier.
Obliged.
Earlier is before, not last occasion, before that. Yes, next one.
No, no.
Re-adjourn. Number 4. Harish Babu, KN for appellant. PB Raju. Raju.
Yes, sir, please.
Pass over. Who appears? Mr. PB Raj. Once he comes, we'll take. Yes, next.
Then number 5. Desham Latur for appellant. Omayesh the respondent.
I am for the appellant, my lord. I have filed this case for enhancement of compensation, my lord.
Case of death or injury.
It is a case of injury, my lord, and the accident has taken place on 10/3/2013. The claim amount is 8 lakhs.
What are the injuries?
Injuries, my lord, communicated fracture of both the bones of the right leg.
How many days he was in hospital?
He was in hospital for 3 days, my lord, and he has taken in a private treatment as an outdoor patient.
Granted 9,000.
Yes,
6,000. Sufficient.
6,000 attendance charges, conveyance, and food and nourishment.
Together, all
has
put
granted.
together, reasonable amount. Yes,
Yes,
pain
my
and
lord.
suffering.
And the income has taken, my lord, only 6,000 rupees, but 8,000 has to be taken as per the notional income chart.
No.
8,000.
6,000. No, 1 minute. What is, according to you, what is your income?
Income, according to me, is 9,000, my lord.
Court had taken 6,000.
6,000.
Here is the accident.
Accident is on 10/3/2013, my lord.
What is the disability?
Disability, as per the doctor evidence, that 54% of the right lower limb, 27% to the whole body, as per the evidence of doctor, my lord.
Let us see that paragraph.
Para 25 of the judgment, my lord. Para 25 of the judgment, page 21.
Yes.
May I read it? Yes. The PW2 has stated that on 25/10/2013, he has examined the petitioner clinically and radiologically for the assessment of this. Yes, my lord.
Where are you reading?
I am 25, para number 25, page 21, my lord.
Yes, read. Yes.
Yes. The PW2 has stated that on 25/10/2013, he examined the petitioner clinically and radiologically for the assessment of disabilities, and the petitioner complained of pain and difficulty in walking a long distance and claiming stairs. He gives a history of inability to squat and sit cross-legged. He has further stated that on examination, the petitioner walks with pain and limping using a walking stick, diffuse edema and swelling of a right leg with knee and ankle is seen. He has further stated that on 25/10/2013, X-ray was taken, which showed malunion fracture of tibia and fibula, middle one-third right leg, and on examination of knee on left side and the right side ankle and disability component and mobility component, it is found that the petitioner is suffering from total disability on right lower limb at 54% and 27% to the whole body. He has further stated that the petitioner is said to be a vegetable vendor and the said disabilities come in the way of his working, and in view of the said disability, it is difficult for the petitioner to do his vegetable business and to do any physical or manual work. So my lord, in this case, the petitioner has on the honorable tribunal has taken it only 10% disability. It is at para number 20. May I read the continuous paras, but relevant para is 27, my lord. So here, para 26, as this tribunal has observed the production of exhibit P8 outpatient record with examination report, exhibit P9 inpatient record.
Yes, we will take it as 18%.
Yes, my lord.
In para 27, my lord, the terminal.
My lord,
I read that.
one submission. My lord, the pain and suffering, loss of amenities, only 20,000 has been granted, my lord. For this
Pain and
general
suffering,
damages,
40,000.
since 20 years, since 20 years, my lord, there is a 50,000. About 20 years back, the honorable, this court has awarded 50,000 for pain and suffering and 50,000 for loss of amenities for a fracture of right hand, my lord.
What is the multiplier?
Multiplier is 11, my lord. Multiplier is 11. So future prospectus of income has to be taken in this case.
In every case, it has to be taken, Mr. Lathur.
Yes, my lord. And now, in this case, 10% has to be taken because the age has taken by the tribunal is 55 years. So 800 is the future prospectus, my lord. So 8,800 has to be taken for income, for assessment of future income, loss of income. So 1,584 is the loss of income.
I'm not considering future prospects. I'm not considering. It comes to 3,26,840. Please come.
May I invite your lordship attention to, my lord,
Yes.
the reasoning of the tribunal. Typed page 23 of the judgment.
Yes.
With reference to exhibit P10 X-ray, my lord, the court observes like this.
Yes.
In exhibit P10 X-ray film, and there is no malunion of tibia, and he has not produced the measurement of the limbs. He has further clearly stated that there is no mention of about 50% disability to be taken to the whole body. So under
Yes.
these circumstances, my lord, the tribunal has come to the conclusion and it doesn't require any modification, my lord, in appeal in view of
Yes.
this.
Yes, yes. Agreed with the award passed in embassy number 2350 of 2013, dated 13th October 2013. The claimant is before this court seeking enhancement of the compensation. The claimant is seeking compensation of an amount of rupees 8 lakhs for the injury sustained by the claimant. It is his case that because of the rash and negligent driving of the driver of the offending vehicle, he had sustained commuted fracture of mid-shaft right leg and other grievous injuries to all over the body. As per the evidence of the doctor, he had sustained 54% of the disability to the limb and 27% to the whole body. The court had considered the disability at 10%, but not 27% as assessed by the doctor. The court gave a finding that based on the oral version of PW1 and PW2, coupled with the reasons, it cannot come to the conclusion that due to the road traffic accident, the claimant is suffering from permanent physical disability of 27% to the whole body, as he has not produced any documents regarding follow-up treatment after the discharge from the Bowring and Lady Curzon Hospital to take further treatment to the fracture injury. Further, the age of the claimant is 55 years as on the date of accident, as per the police and medical documents. And more so, PW2 in his cross-examination has clearly stated that they have not conducted a surgery to the petitioner in their hospital. The petitioner is discharged against medical advice, and he has not seen the medical documents about the treatment taken by the petitioner in any other clinic or hospital. Hence, the court had taken the disability at 10% and granted the compensation as per the table given below, and altogether granted compensation of an amount of rupees 1,37,200. And counsel appearing for the claimant submits that the court had failed to grant a just and reasonable compensation when the doctor has reported there is 27% disability to the whole body. Court without any basis had taken 10% and the salary was taken at 6,000 and ought to have taken uh, ought to have taken 8,000 per month. 2013 accident.
Yes, my lord.
It comes to 3,80,000 rupees. What did you write? At 8,000, but the court had taken 6,000 as a salary, and the disability also taken at 10%, which is not, which is contrary to the record. Next paragraph. Land counsel appearing for the insurance company submits that court had rightly considered the disability at 10%, and the compensation that was awarded by the tribunal is just and reasonable, and no grounds are made of seeking enhancement. Next part. This court has perused so and so, or the counsels and perused. Under the head of pain and suffering, considering one grievous injury, this court is granting 40,000. The court under the head of transport, conveyance and attendant has granted 6,000, which is a reasonable amount, and no enhancement is called for. As this is an accident of 2013, this court is taking the income as per the chart prepared with the Legal Services Authority at rupees 8,000. And for 3 months it comes to 24,000. Then coming to the disability, the court doctor had deposed that the disability is 54% to the whole body, to the limb, and the whole body 24%. 1/3 of 54% would come to 18. The reason that was given by the court to consider it at 10% disability, this court finds that that is without any basis. Hence, the disability is taken at 18%. 8,000 into 12 into 11 into 18 by 100 is 1,90,081. Coming to the loss of immunities, this court is granting 30,000 towards legal expenses in the light of the law laid down so and so 10,000. Altogether, the claimant is entitled for an amount of 3,80,000 rupees. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,37,200 to 3,80,000.
Cell number
Yes, next.
6, Kalyan R for appellant, PB Raju for respondent.
Yes.
For appellant.
Well, this matter was heard, my lord, on the last occasion. Well, the case of the insurance company, my lord, that it was a long-term policy, and the policy was issued only till the.
No, that time Mr.
Yes, ma'am.
Ravi Sampati was saying some judgment.
Yes, my lord. He has brought it, my lord. Para 19 of the.
Other idon judgment ಇದೆ. 6718/14.
Do that.
ಅದರಲ್ಲಿ para 19 ಇದೆ.
ಹ್ಮ್.
67.
6718/14. ಇನ್ನು
So in the light of the same insurance company, appeal has to go. Then what
And
about your enhanced?
finding of the my lord, MSCT is at para 16. Says, my lord, the last line, my lord, the policy deemed to have been cancelled before the accident since it is not renewed.
Where
Your
is
lordship
that?
could say para 16.
On
The
file.
last 3 lines, my lord, is the finding. Page 17, my lord, page 17, para 16.
Oh.
Like the last 5 lines, my lord. So the court comes to the conclusion that since it was not renewed, it's deemed to have been cancelled, which is against the law.
Then what about enhancement? What are the injuries?
It's right leg, 2 broken bones.
Both bones of fracture of both bones of right leg. Man.
One leg.
On right leg.
Right leg.
50 reasonable amount. 50,000 parents suffering is reasonable.
The 2010
Oh, yeah.
accident, my lord, I think the overall, my lord, if your lordship could consider the entire on its entirety appears to be reasonable.
Medical expenses 43. How many days he was in hospital?
7 days he was in. 7 days he was in inpatient.
10,000 is granted. Already 3,000 extra there.
No,
10,000 extra here.
No, it's he was hospital for
Then
7 days.
loss of income during the later period. Which year is the accident?
2013, madam.
2013. It is 8,000.
He was working as a courier.
No, 8,000.
8,000.
If you take 2 months, it would be 16,000. Court had granted 18,000. Then
Okay.
loss of future income. There, some difference it will make. So, pain and suffering 50,000, medical
your lordship could reassess, my lord, 50,000 is on the higher side compared to 2013.
40,000 we will take.
No, my lord. Sorry, my lord. Because he was 20 years old and he's working
It
as.
doesn't matter, pain and suffering for everyone the same.
But he was hospital for.
No, this is standard how the court is granting in all the matters. Pain and suffering, if their appeal also is not there, we would have not
Our
touched
appeal is
that.
there.
That's what I'm saying. If it is not there,
Otherwise 50,000.
then,
Otherwise 50,000 is.
no. If you want 50,000 and leave it there, then I will not enhance on other accounts. Loss of future income. Now, if it is 2013, we have to take 8,000. There you will get the enhancement. If you don't want that, then we'll leave it here. Nourishment conveyanced 7,000. Loss of income during laid up period. Generally, we are granting 3 months in these kind of cases. So, 2013 accident into 3, 24,000. Loss of future income. What is the evidence of the doctor?
Doctor says 39% of the whole limb. And
To the whole body?
yes, to the
And
whole
to the
body.
limb?
But the tribunal comes to the conclusion, my
24%.
lord, that 1/3 of the disability, it is taken as 24%, my lord.
No, 18%.
And 8%.
No, no,
my lord.
8%
8% of the whole body and 24% of limb, my lord. The tribunal takes it as limb. Kindly see, my lord, the doctor says 24% of the whole body, my lord.
Where is that?
Para 12, my lord. Para 12, the last 3 lines. PW2, Dr. Ramesh has supported. He stated that petitioner is suffering from permanent disability of 24%.
No, he said 24% to the right lower limb and 12% to the whole body.
Whole body.
Court had taken 1/3.
1/3.
Correct.
It's 8%.
Multiplier 18 is correct.
Yes, ma'am.
What is the evidence of the doctor with regard to the future medical expenses?
No evidence, my lord. Para 15, my lord, the court records a finding that he has to undergo one more surgery for removal of implants.
No, that's true. But what is the doctor's evidence with regard to the expenditure?
PW2 has deposed that cost of future surgery is 10,000.
30,000.
10, my lord.
He said 10,000.
It's there in para 15.
It comes to 3,02,240 from 2,60,000.
The enhancement would be 40,000 to
42,000.
But the interest may be reduced. It's 9% may be reduced.
Interest is 9%. We'll make it 6%.
Or 8% is. First taken 9%.
I think my learned friend should have appreciated the My lord, fairness of the insurance company was losing the case that day.
Generally,
We
you know,
gave
like,
him the judgment.
In all these cases, no argument is required because it's common. If insurance company's appeal is there, we will, if not also on the enhanced amount, 6% only will be given. 8% will not be given or 9% as granted by the tribunal. Agreed with the orders passed in MSC number 5130 of 2013. Both the insurance company as well as the claimant are before this court. The insurance company's appeal is MFA 411 of 2016 and the claimant's appeal is MFA 411 of 2016 and the claimant's appeal is MFA number 6720 of 2015. The claim petition is filed seeking compensation of an amount of rupees 5 lakhs for the injuries sustained by the claimant in the accident that took place on 2/9/2013. It is a case of the claimant that the claimant was aged 20 years, working as a courier delivery boy, and was getting monthly income of rupees 8,000. On 2/9/2013, at about 12:45 p.m., he was standing near the Madha Naikanahalli bus stop to cross the other side of the NH4 Bangalore-Tumkur road to go to Siddhanahalli carefully and cautiously. At the time, scooter ridden by its rider in a rash and negligent manner with high speed, neglecting all the traffic rules and regulations, came and dashed against the petition claimant. Due to the impact, he fell down and sustained grievous injuries. The insurance company has resisted the claim. According to them, it is a case of the insurance company that the respondents have denied the liability to indemnify the respondent number 2 and to compensate the claimant on the ground that the policy issued in favor of the respondent number 2 was a long-term act-only policy, that it was valid till expiry of fitness certificate or till cancellation of the registration certificate, that the registration certificate oblique fitness certificate of said vehicle was valid till 12/1/2010. Therefore, the policy is deemed to have been cancelled before the accident and they are not liable to pay the compensation. In that regard, they have examined RW1, Sudhindra, IRTO, Rajaji Nagar, Bangalore, and RW2, the administrative officer, and marked exhibit R1 to R4. The tribunal gave a finding that
Para 16.
Para?
16. The last one left. Para 16.
Para 16.
Yes. The last 5 lines.
Hmm?
The last 5 lines of para 16 says, that the respondent number 10 was a long time.
No, that's not the finding.
It comes to the conclusion, the policy deemed to have been cancelled before the accident. It had expired on.
The court has observed that the policy issued with respondent number 1 is valid till cancellation of registration and not till expiry of the fitness certificate. Evidence of RW1 and 2 and contents of exhibit R1 to 4 are not sufficient to hold that the registration certificate of the scooter was ever cancelled and accordingly held that the insurance company is liable to pay the compensation. When it comes to the compensation, court had granted an amount of rupees 2,60,000 as per the table given below at para number 15 extract. Learned counsel appearing for the insurance company submits that as it is a long-term act-only policy, as it was valid till the expiry of the fitness certificate, and in this case, that was valid till 21/2/2010. As such, the insurance company is not liable to pay the compensation. Then counsel also submitted that even on the other counts, even on the compensation also, the amount that was awarded by the tribunal is on the higher side. and the same needs to be set aside. Next, and counsel appealing for the claimant submits that when the insurance company is saying that the fitness certificate uh, that it's a long-term policy, uh, it was valid till expiry of the fitness certificate or the cancellation of registration certificate. They have failed to examine the concern and they have failed to elicit the same. He had relied on an order passed for the coordinate bench of this court in United India Insurance Company Limited versus Srimati Lakshmamma and others, dated 14th December 2022, submits that this court, in the said judgment, coordinate bench has held that the very contention of the insurance company that merely uh, because of non-renewal of the RC, the liability cannot be fastened on them, cannot be accepted. And apart from that, in the evidence of the insurance company, the witness who has been examined as odd everyone also categorically admitted that registration certificate is not cancelled. On perusal of Exhibit R2 also, it is very clear that the liability is still the cancellation of RC, and explicit contract between the insured and the insurer is till the cancellation of the policy. And since no policy is cancelled, the very contention of the insurance company cannot be accepted. Then counsel submits that the tribunal had the tribunal had rightly held the insurance company is liable, and in the light of this, the judgment refers supra. Still, the insurance company is liable to pay the compensation as there is a valid insurance policy. Then, coming to the compensation, he submits that the court ought not to have taken the income at 6,000. According to his case, he is earning an amount of rupees 8,000 per month, and even the uh, considering the disability on 8% is also on the lower side. Next slide. The under the head of pain and suffering, considering the claimant had sustained one grievous injury, this court is granting an amount of rupees 40,000. There is no dispute on medical bills towards nourishment, conveyance, and transport. Court had rightly A court had granted 10,000 when he was in hospital for a period of 7 days, and the same is reduced to 7,000, and the pain and suffering is reduced to 40,000. Coming to the loss of income during the later period, as is an accident of 2013, court is taking 8,000, 8 into 3, 24,000. Loss of future income, as the court had taken 8,000. Coming to the disability, according to the doctor, the whole body disability is 24. The disability to the limb is 24%, and to the whole body, it is 12%. The court had rightly taken 8%, one third of it, and hence 8,000 into 12 into 18 into 8 by 100 is 1,38,240. Loss of amenities, this court is granting 30,000. Future medical expenses, no interference is called for. In the light of the law laid down in so and so legal expenses, accordingly, appeal is partly allowed, enhancing the compensation from 2,60,000 to 3,02,240. The amount in deposit shall be forthwith transferred to the trial court. Yes, next.
Cell number 7. Babu M for appellant, A.M. Venkatesh for respondent.
No representation, it's already in dismissal.
Housing.
Do that. On 21/3/2025, as there was no representation, the matter was directed to be listed under under the caption for dismissal on 22/3/2025. Again, on 22/3/2025, as there is no representation on behalf of the appellant, the matter was directed to be listed under the same caption on 1/4/2025. Today also there is no representation on behalf of the appellant. Accordingly, the appeal is dismissed for non-prosecution. Next date.
Cell number 8. Kala Kumar for appellant.
Seeking enhancement or dismissal?
My lord, claim petition is dismissed on only one ground, that the offending vehicle, the TVS XL was not involved in that was not proved. They are causing of the accident. That is only one ground, madam. The FIR is against the offending vehicle, charge sheet is against the complainant is the rider of the motorbike, which was
Please come to that finding, let's see.
paragraph, page 15, para 9, my lord, last 8th page, from last 8th line, my lord. The oral and documentary evidence on record reveals that the petitioner sustained the
Para number 9.
para number 9, last but 8, my lord, from 8, that is the relevant.
Yes, yes, yes.
That the petitioner sustained a commuted fracture of right tibia condyle with vascular injury impeding compartment system syndrome on 12/5/23 in 13 on RTA, but there are doubt circumstances of the involvement of the TVS XL super bearing number KA 406469 in the accident. Contents of the Panchanama Exhibit 2 and 12 reveal that the motorcycle bearing number so and so was
There is the MLC extract.
MLC extract is Exhibit 5, my lords.
Exhibit
Exhibit 5.
is a wound certificate.
Sorry, one second. MLC exhibit.
MLC extract has not been.
Exhibit is not given, my lord.
That's one of the grounds, my lord, which has been.
Exhibit
Not there.
Not there.
P5.
P5 is the own certificate, my lord.
Right, in the same paragraph, it says, what the tribunal notes is that the vehicle in which he was traveling was detained by the police on 29/5/2013. And the other vehicle, that is the insured vehicle, my lord, has been, my lord, detained on 16/6/2013.
When the
There was a
accident had
delay of
taken
16
place.
There was a delay of 17 days, my lord.
16 days in filing the FIR, my lord.
What was the accident?
My
On
lord,
12/5/2013.
12?
12/5/2013.
Then as on that day, the vehicle is with the police.
No, it was not.
It was not confiscated.
My lord,
No.
the rider of the vehicle.
You are saying that one vehicle is detained by the police on 29/4/2000.
29/5.
29/5. Other is 15/6.
16/6.
So what it says?
And it also refers to IMV reports, my lord, Exhibit P3 and P4.
Observation that IME report, there is no damage to the vehicles.
There was no damage to both the vehicles.
Because since the vehicle was seized after a long time, my lord, that may be got repaired. That is not the issue.
Where do you get with regard to the wound certificate with regard to the
Wound ticket was
about the road traffic accident?
only that was mentioned RTA, my lord.
Where do you get that? History RTA
Yes, that is all, my lord.
on the same day.
No, it is not the same day, my lord. Oh, it was issued on the same day. That is on 13th next day.
Why you have not filed the MLC extract?
Oh, they were not obtained, my lord. You immediately was admitted to the Kunigal hospital.
It's
The
okay.
government
No,
hospital. From
no,
there, for
no,
the
no.
higher treatment,
There
was
is a-
shifted to the.
There is a delay in giving the complaint. All the more reason that you have to file the MLC extract.
That is there, my lord. But somehow, yes, that was.
But if
It
your
is the
lordship
duty of the doctor. They should have reported to the police immediately.
Correct. That
Accident
is
is
his
not
duty.
denied. Injury is not denied.
That is his duty, but when you file the petition, it's your duty to,
It was
substantiate
long
your case.
hospitalized for 29 days, my lord.
Your
We will
lordship,
forget about the delay in giving the complaint. Sir. It is about the MLC extract. We have to know Whether what has been stated. before
Because
the-
of his lack of knowledge and this one, he was not this one. Because the text only. Otherwise, the charge sheet is against the offending vehicle. The FIR is, the complainant is the rider of the vehicle which was involved in the accident.
Yes, what do you say?
My lord, if your lordship could see page 8, my lord, 8 of the judgment. In fact, my lord, the complainant Muddegowda, who was riding the bike, did not sustain any injury. He doesn't file any complaint, my lord. And also says that he was first admitted in Kunigal, my lord, HPHC, primary health center. And no document has been produced from Kunigal hospital also. And also this hospital, my lord, MLC extract, to know the nature of the accident. And the other vehicle, my lord, the insured vehicle has been, my lord, confiscated only after, my lord, 17 days after the accident. Not even 17 days. 1 month, 4 days, my lord. 34 days, after 34 days.
No, that is a delay on the part of the police. They have
And the
given
court also comes to the conclusion, if your lordship puts, the petitioner has not produced the wound certificate issued by CHC Kunigal, where he was taken at the first instance, my lord.
Immediately
Thereafter,
shifted
he was
there.
taken to the other hospital.
From there, immediately shifted to the Aditya Orthocure.
And even in the medical records, my lord, it also notes, if your lordship could see page 8, my lord, 5th line, there are no details of date, time and place of accident and vehicles involved in the medical records. And the person who was riding the bike had not sustained any injury. And he has not filed any complaint, my lord. The complaint has been lodged after a lapse of 17 days, my lord. And no damages to both the vehicles.
He was also injured, my lord. He was taking care of the appellant, was hospitalized for 29 days.
And the doctor's evidence.
Thirdly, PW1 has stated that. Who is Muddanagowda?
Then he was the rider of the
bike. And
Payment is pillion rider.
Yes. And
He was the
doctor
pillion rider,
also
but-
says, my lord, that he was conscious when he was admitted to the hospital. It's in English, my lord. The evidence is in English, my lord. The doctor's evidence. In fact, he could have gone against his own vehicle because he was a pillion rider, my lord.
Injury is not denied, accident is not denied. Only thing, the involvement of
The contents of my police records and medical records are inconsistent with the manner of accident and involvement of TVS so and so.
Even the court notes, my lord, that his evidence also is inconsistent with the medical records.
as far as the charge sheet and FIR is this one, my lord. There is no any inconsistent on the accident is not denied. While dismissing also, only thing, the involvement of the offending vehicle is not proved. To the extent only the honorable tribunal has dismissed.
Let's say
They are not-
other circumstances would be, my lord. The owner and the.
There is no any
insurer of the-
rebuttable evidence to
He was riding, my lord.
to deny the
He had made them parties, probably, my lord, the insurance, probably it had no insurance. Therefore, my lord, after lapse of, my lord, 17 days, the complaint has been lodged. Wherein previous, if the insured vehicle, my lord, has been mentioned. This is evident, my lord, from the fact that the vehicle is not damaged.
there is no any rebuttable
Records
evidence. They
do
are
not
not,
reflect all
at least
these
they should
facts.
examine the IO.
With the orders passed in MVC number 5204 of 2013 dated what is 8th April 2015. Agreed with the dismissal. The claimant is before this court. Claim petition is filed on section 166 of the Motor Vehicles Act, seeking compensation of 10 lakhs. It is a case of the claimant that on 12/5/2013 at about 8:45 a.m. he is proceeding on a motorbike as pillion rider. The said motorcycle was ridden by one Muddegowda when they reached near the underbridge of New Bypass, Begur. At the time, TVS Excel came at a very high speed in a rash and negligent manner and took sudden right turn and dashed against the motorbike. Due to the impact, he fell down. The rider and the pillion rider fell down, and the pillion rider sustained the injuries. Immediately, he was taken to CHC Kunigal, and then he was shifted to Aditya Orthopedic and Trauma Center, Tumkur, where he was admitted as an inpatient from 12/5/2013 to 10/6/2013. And yet, the claimant had sustained comminuted right tibial condyle fracture with vascular injury, impeding compartment syndrome, and he had underwent surgery of right leg and aorif with buttress plate fixation and fascectomy done, and he was discharged with an advice to take follow-up treatment. And he has spent huge amounts for treatment. The court had dismissed the claim petition, observing that it is stated that according to PW1, the rider Muddegowda sustained simple injuries. The said injured kept quiet for 16 days to report the matter to the police. The charge sheet does not disclose that the complainant Muddegowda sustained injury. The 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 said Muddegowda has not made any efforts to get back his motorcycle immediately, and the wound certificate issued by CHC Kunigal, where he was admitted, were not produced. There are no details of date, time, and place of accident and vehicle involved therein in the medical records. Oral evidence of PW 1 and 2 and contents of Exhibit P1 to P15 indicate that on 12/5/2013, the claimant met with an RTA and sustained fracture injury, but the contents of police records and medical records are inconsistent with the manner of accident and involvement of the TVS XL Super as reposed by the claimant. The delay in lodging the complaint is unexplained, and the court also observes that there are no damages to both the vehicles. And further, there was no chance of motorcycle lying in the place of accident for 17 days. And also no evidence as to sustaining the injuries by the rider of the motorcycle and the rider of the TVS XL. Then the court came to the conclusion that the said vehicle was not involved in the accident and accordingly dismissed the petition. Then counsel appealing to the petitioner submits that when the medical records are consistent and also pointing out at the negligence of the offending vehicle, court had failed to consider the same and dismissed the application. It is submitted that in fact, he had discharged his burden, and the burden lies on the insurance company, which they failed to discharge, and still the court had dismissed the claim petition filed by the claimant. Next parallel, and counsel appearing for the insurance company submits that when he was admitted in the Kunigal hospital and later to the hospital at Tumkur, he has not filed the MLC register or any other relevant documents pertaining to this relevant documents for the court. And Exhibit P16, which is filed by him, shows that what is P16? Wound certificate.
P5, my lord.
Huh?
Exhibit P5.
Exhibit P5, the wound certificate only refers to RTA and no other details are found in Exhibit P5. He stated that the court had rightly observed about the involvement of the vehicle and the discrepancies in the charge sheet and in the evidence of PW1 with regard to the injuries sustained by Muddegowda and also the delay in how much is the delay?
16 days.
16 days delay in giving the complaint and rightly dismiss the petition. Submitted that there are no grounds to interfere with the order passed by the tribunal. Having heard the counsel, so in this case, the complaint is given 16 days from the date of the accident. The rider of the vehicle is one Muddegowda. According to the claimant, he had sustained simple injuries. According to as per the charge sheet, even they are not mentioned. The complaint is given by Muddegowda. Muddegowda, and the delay is about 16 days. Why? For what reason? The delay is given, the complaint is given after 16 days. There is no explanation forthcoming. Then when there is already a delay on the part of in giving the complaint, then if the claimant had sustained injuries and was admitted in the hospital, there would be the MLC the MLC the register extract should have been placed before the court. The claimant has failed to place the same. And considering the delay, the case of PW1 and the discrepancy in the medical records, the court had rightly come to the conclusion that the claimant has failed to prove the involvement of the vehicle. In the considered opinion of this court, the findings arrived at by the tribunal are based on evidence and no interference is called for. Accordingly, dismissed. Yes. Huh?
Cell number 9, Ramachandra Nayak for appellant.
This is an appeal of 2016. No steps were taken for service of notice on respondent right from 2016. And earlier, right from ask them why that sounds for everything. Every time they switch it on, it's sounding. Ask them. Right from 2016, it is pending before the registrar. When it came up on 19th, 2020 before the court, time is granted to comply with to do the needful. And it has been in spite of the same, no process is paid for service of notice on the respondents on 8/1/2025. Time is granted. Again, like 13/2/2025, there was a direction to pose this matter for dismissal. Today also, there is no representation. It appears that the applicant is not interested to pursue the matter, and this appeal being an appeal of 2016, same is dismissed for non-prosecution. Yes, next.
Cell number 10, Sripad V. Shastri for appellant.
I am for appellant, my lord, no insurance, my lord. And whether the owner of the vehicle today present or not, actually in his case, owner's case, my lord, R6 notice awaited. R6
counsel appearing for the claimant, no representation for the respondent, owner of the vehicle. This matter as part heard on 16th of April.
Cell number 11.
My lord, sorry, my lord. See, my lord, I am out of station from 10 to 20, my lord. Before 8, 9 or after 20. Any
on
date.
23rd.
Lord, in this case,
Cell number 11.
in this case, a report was called for from there. But however, the report has they were never sent. But As on today, my lord, the appellant has lost both the eyes. I got the two hospital report. Kindly see, peruse the report.
Let him, let him place it on record.
Kindly see that.
No, it's not on record.
No, Minto hospital only. It is on same
No,
hospital.
no, just like that, the court can't take it.
I will file it. I will file it. And also, in the event, suppose, now your lordship may refer him to the same Minto hospital for, because as on today, he has lost both the eyes.
It is submitted that
And he
earlier,
is present before the court also.
earlier, it is a case, it is a case of the claimant that he has lost what was vision
Both
in
the
one
eyes,
eye
both the,
earlier,
earlier, he lost left eye.
vision in the left eye.
Yes.
It is submitted that now he has lost the vision
Both the eyes.
in the right eye also. And he has placed some document before the court,
Yes.
the report before the court. Hence, this court deems it appropriate to refer the matter to which hospital?
At the Minto hospital only.
There is a reference, already there is a reference, my lord.
No,
Still
it
it
is
is.
Now, same hospital.
Please, Minto hospital only.
Minto hospital.
Minto.
Minto
Eye hospital.
Minto Eye Hospital, Bangalore.
Bangalore.
And the registrar judicial is directed to communicate the same, and the appellant shall appear
A date may be given.
on, we'll say 22nd April, on 22nd April, and immediately the report shall be placed before the court.
Yes.
And the registrar judicial shall make all the efforts. If the court observed that earlier, though the order was passed long back, no efforts were made till now to get to place a report before the court. Yes.
Yes.
Cell
Next.
number 12. Manjula Devi Kamalurli and appellant.
No representation. Post this matter for dismissal. Yes.
9.
Yes.
9-4. Cell number 13.
My lord, in this case, I am for respond number 3, my lord, in first case. And in the cross appeal, I am the appellant, my lord. 2012 matter, my lord, accident is. In this case, notice was not served to the respondents. The respond number 1 is died on 24/7/2018, my lord. One Ashok is a claimant before the trial court. Before this court, respondent, the appellant challenging the judgment and award, and no steps are taken. Voluntarily, the respondent number 2 and 3 appeared before this court, my lord. And another 3.1 is a D-link, no way connected to this case, 13.1. 13.2 only connected to this main
It is
appeal.
submitted that 13.1 MFA number 16720 of 2022 is unconnected with the other cases. These three is directed to dealing the same.
And the applicants are filed the application.
If not filing the LR petition. He's muted or
Is in
Vijay Kumar sir. He is unmuted only.
you're not audible.
You are not audible to the court, sir.
Yes, this is matter. Muted. This is matter on 15th April. Yes, next.
Cell number 14. Mr.
R3
Manish.
is the minor girl died. R1 and R2 is the LR Satya disease. That is why.
One more regarding the service of R4. R4 is the insurance company. Any
No,
panel
first of all,
advocate?
1 minute. Not taking of steps in respect of R3.
There is no LR. She is the minor.
No, you have to file a memo to that effect.
Today only I'll file the memo.
For complying with the objections. Let's this matter on 16th of April.
Regarding R4 matter is the insurance company. Any panel advocate may be listed.
Which insurance company it is?
Bajaj Alliance.
Beep.
Serve the copy. Bajaj Allianz General Insurance.
HR and Renuka is directed to take notice on behalf of the respondent insurance company, land counsel for the appellant shall serve the appeal memo on the counsel. Next, with regard to the complying with the other objections, this matter, and by 17th of April, the said objections shall be complied with.
Okay.
And list this matter on that day. Yes, give that list. Yes, next.
Cell number 15. Cell number 15, Samir SN.
Huh? Give that memo. Memo is seeking dispensation of notice on respondent number 1 stating that the liability is fixed on the insurance company. Accordingly, memo is taken on record. Notice to so and so is this, take this notice to so and so is dispensed with.
But the matter could be disposed of here itself because it's, I think the injuries are very severe in nature.
Yes. So both the parties, this is not before the Lokatara. This is the registrar is directed to communicate the same. Yes, next.
Cell number 16, hearing on interlocutor applications. Be
My lord,
present.
two appeals, one from the insurance company, one from the claimant, my lord.
You are on what ground?
That the transport endorsement issue, Mukund Devan's case covers.
Will apply. So your appeal has gone. Then it's a case of death or injury.
Injury case.
Get it? Come to the table.
Table, internal page 13.
Well, 2 points involved, my lord, 2 points. As far as claimant side is concerned.
Negligence fixed.
Well, one is merely because driving license not produced, 25% negligence is foisted on the claimant, my lord. That is not sustainable in the eye of
What do you
law.
say on that?
25% negligence is considered. There is an U-turn. The MSCT has observed not only the driving license, my lord, and he doesn't have driving license. So while he was taking U-turn, my vehicle is going on a straight road. The cause of accident is
Not
like
taken
this.
precaution. That's
Please.
My lord, the main this one is my lord only driving license, my lord. Since he failed to produce a driving license, 25% is on the claimant. That is the observation of the
MSCT observed like this. Internal page 18, my lord, MSCT has observed he doesn't have license to ride the motorcycle. Conclusion is that, my lord. What my lord friend saying is that internal page 18. As the accident is collision between the two vehicles in the middle of the parameter. Petitioner not holding license, definitely certain extent of liability to be fixed in investing. Hence, I am of the opinion at least 25%
where
liability.
is the finding with regard to the contributory?
Only this finding has given, my lord. But narration of accident is that, my lord, while motorcycle rider was riding a KA04 EG 8874, at the time luggage auto rickshaw came with high speed rash and negligent manner and dashed against the motorcycle.
First of all, there should be
The
a finding.
issues may kindly be some.
No. First of all, there should be a finding on contributory negligence.
Not given.
Then
Only
straight away a DL.
DL.
No, you are saying
That-
about U-turn and all. Where is that?
That
No,
issue is the issue number 1, my lord, internal page 5.
Yes.
Whether the petitioner proves that on 29 to 2013 at about 4:45 p.m. he was proceeding on a Boxer motorcycle bearing number while taking a turn near Gadasahalli village, Kasba Hobli, Kanakpura Taluk, a pickup auto.
I'm not able to see that. Where are you reading?
Issue, my lord, issue. Issues
You're
framed, my
reading
lord, but
issues,
issues not given answer to that. Straight away, the answer is given, he is not having license.
What do you say?
There is no counter evidence.
So contributory negligence
Contributory
also
negligence.
gone. So come to the compensation.
Compensation very limited ground, my lord. It's a very limited ground.
What is the very limited ground?
Loss of amenities, no compensation awarded.
Towards pain, how many are the injuries?
My lord, fracture of
Fracture of
right
femur.
femur, comminuted fracture of right femur, and cut lacerated wound over right leg and wrist.
Only
My lord.
one?
Only one fracture.
So we'll make it
20,
40,000.
50 has already given.
That's why we'll
50,
make it 40.
that's why.
Please, please.
My lord,
Yes.
20 days inpatient. My lord,
Mr.
if my lord
Shastri,
permit, my lord, my lord.
we will make pain and agony 40,000. One's fracture.
My lord, bone grafting is done. Open reduction internal fixation was done, and it is still in situ. It requires removal. So he has to undergo 3 surgeries. Two is already
How
underwent.
many days? How many days he was in hospital?
20 days, 20 days, my lord,
Then
20
why the
days.
court had granted food and nourishment 40,000? Attendant charges 15,000, 55,000. Now is he entitled for 20 days?
2000 and follow up, my lord. Yeah,
Not
regularly.
follow up. Food and nourishment attendant charges coming to 55,000.
Mostly is eating tonics and other things. I can't explain, my lord. I can't explain. It is left to the court, my lord. I am not so much keen about the enhancement or other things. Matter
No,
is to be
yes,
disposed of.
for about 40 days, not 20 days.
40 days, huh?
40 days. Internal page 12.
Anyway, he's not keen on enhancement. We'll leave it there.
Loss of amenities, my lord, no compensation
No,
awarded.
just now you said that you are not keen on enhancement. We'll leave it there.
Not too much, not too much. That is why there is no this exchange business. There is only what is the head which is required to be enhanced. That is the loss of amenities. No compensation is awarded. And as far as income is concerned, my lord, it is extent is of the year 2013, my lord.
Lord?
How much is the disability?
Disability, doctor assess 40% to the limb and 12% to the whole body. The same has been considered.
So
They
then
themselves have claimed that he was earning 6,000 per month.
no, we will take another for towards amenity. How much you said? 15%.
12%.
12% whole body.
We will take 20,000. So then 3,66,000, another 20,000. 3,80,000, 342. 10,000 legal.
It may be closed.
90,000, 342. Agreed with the order passed on MBC number 5518 of 2013. Both the insurance company and the claimant are before this court. Now, before that, IA number 1 of 15 is filed to condone the delay of 16 days in filing. Same, considering the reasons stated, the delay is condoned. The next main order. The insurance company's appeal is MFA number 8543 of 2015, and the claimant's appeal is MFA number 7449 of 2015. The claim petition is filed seeking compensation of an amount of rupees how much? Seeking compensation for the injuries sustained by the claimant in the road traffic accident. It's a case of the claimant that on 29/2013 at about 4:45 p.m. the claimant was proceeding by riding the motorcycle. At that time, a pickup van, auto rickshaw, came in a high speed in a rash and negligent manner from opposite direction, dashed the motorcycle of the claimant. As a result, he fell down and sustained injuries. He was taken to the hospital in an ambulance. After first aid, he was shifted to the Friends Hospital. He spent a huge amount for treatment and other expenses. It is a case of the claimant that he is working as a cashier at Aishwarya Bar and Restaurant and earning for 6,000 per month. And as per the evidence of the doctor, he has sustained disability of
40%.
the limb and
12% to the whole body.
12% to whole body.
12% to the whole body. Same was taken.
Same also.
12% to the whole body. The court had taken 6,000 as income. and accordingly granted the compensation as per the table given below. Extract the table. An amount of rupees 3,66,342 was granted as a compensation. When it comes to the liability, the court has held that the 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 driver of the offending vehicle is having a license to drive a LMV non-transport and is driving a transport vehicle. As such, the insurance company is not liable to pay the compensation. And when it comes to the compensation, it is said that there is a contributory negligence on the part of the claimant, as he was not having a driving license, uh, and uh, and as such, and he also contributed to the accident, and fixed the contributed accidents at 25%. 25% on the claimant, and accordingly directed the insurance company to pay an amount of rupees 75, the amount of 75% of 3,66,342. Next parallel, and counsel appearing for the insurance company submits that the court had rightly held that the insurance company is not liable to pay the compensation.
Well,
Insurance company liable. Insurance company liable.
Insurance company basically that I have
Stated
challenged.
that the court had fixed the liability on the insurance company in spite of the fact that the driver of the offending vehicle was not having a valid driving license. Further, it is submitted that the compensation that was awarded by the court is on the higher side, and counsel appearing with the respondent claimant submits that the court had not granted reasonable compensation, and there is no basis for fixing the contributory negligence, and it is submitted that the compensation that was awarded is not just and reasonable. Next para. The coming to the liability, heard so and so. Coming to the liability, the court had rightly held that the insurance company is liable in the light of the law laid down in Mukund Devgan's case, that with regard to transport and non-transport light motor vehicle license, the insurance company is liable and no interference is called for. Then coming to the contributory negligence, the court had framed an issue, no discussion, no evidence, just because the claimant is not having the policy, the claimant is not having a driving license, that itself cannot be a ground to that itself cannot be a ground to to come to the conclusion that there is contributory negligence on the part of the claimant uh, uh, on the part of the claimant. This court has perused the order absolutely except framing the issues. There is no discussion. One minute. To be here now, it is easy for me. It is discussion of the argument. The court had the court without any basis, without any discussion, had fixed the liability on the contributory negligence on the claimant to 25%, which is contrary to the which is without any finding in view of the same. The set finding of the tribunal needs to be set aside. Then coming to the compensation, then counsel submits that no amount is granted under the head of I'm writing here only. No, the court has
Loss
not
of amenities.
any amount under the head of loss of amenities. Hence, this court is granting an amount of 20,000 in the light of the law laid down in legal offices so and so. Legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 3,90,342. Accordingly, the appeal of the claimant is partly allowed, and the appeal of the insurance company is dismissed. Amount in deposit shall be forthwith transferred. Yes, next.
Cell number 17, Renuka HR.
Notice has to.
What is happening in 2000 from 2016?
What happened, my lord? We were not aware of the fact that only after the court, Shara came with a statement that she's no more. My lord.
Notice on IA number 123. Yes.
Serial number 18, substituted service.
My lord, I am for the
Appellant,
first
my lord.
respondent, my lord.
Osadiganta Bengal.
First respondent. I am for the first respondent.
Yes.
For R2, madam, I have filed application for substituted service.
As per the order.
Am I audible, my lord? Am I
You are
audible?
audible. IA is for R1.
Please, my lord. Because in the previous case, I was not.
Yeah, 1 of 25 is filed for substituted service of notice on R2 by way of publication is so and so, so and so. Same is ordered. Yes.
For admission matter, serial number 19, Vijay Krishna Bhatt M for appellant.
Yes, 19,
I am
20,
appearing for respondent.
19, 20, 21, 22,
23 adjourned.
20, 23 adjourned.
Yes.
Till 22, all these 4 matters of 2013 shall come in the second list tomorrow. No, second list. Second list tomorrow. Then MFA, 20, what about 24?
24 ready,
only pay and recovery.
Yes, my lord.
That's the only issue.
That is
Only
the
issue, my lord. Expired DL for
All
9
4
months.
cases. I filed for enhancement, doctor evidence, no. That is, the lordship, the.
There are so many appeals.
No, I have filed 2 appeals, my lord.
But then other appeals have to.
Other appeals
By
I
the
filed for
claimant.
enhancement of compensation.
No, that we will not do. 2021, I am hearing only till 2016.
Please, then matter may be taken next time.
No, we will dismiss your appeals. Their enhancement will be heard later.
Oh, my lord. Pay and recovery.
Or 24, right from 24. Unless these matters, any IAs? In 24.2, I number 1 of 21 to 308 days, same. The on condition that they are not entitled for enhancement. 24.3 also there is another one. Then 20, yes. So admit post these matters for final hearing. TCR is already there. Yes.
Date.
Serial number 20. Date.
Yes, next.
Serial number 25, Srinivasaya for appellant.
Representative CR
Ravishankar.
Ravishankar CR not filing of amended cost title.
Check Millard, yes. Carried out the amendment. He has filed appeal memo also.
He has filed amended cost title.
Please. Cost title.
It is submitted that they have already filed the amended cost title. List this matter. Admit post this matter for final hearing. Yes, next.
Serial number 26, Siddharth Prasad Payas for petitioner. A. Madhusudan Rao.
For all 2.
What is this?
This is the matter, my lord. 3 IAs, my lord, we are challenged. IA number 46, 47, 48, and 49. Challenge before my lord. Date may be fixed, my lord, on the 9th. Date may be fixed on the 9th. Date may be fixed, my lord, on the 9th.
No, I'm not able to understand what is this for CPC matter.
CPC, my lord. Is the special orders, my lord, listed before my lords. My lords have heard for some time, my lord, this matter and posted it for today.
Special order.
Oh, this is this matter.
Yes, my lord.
Just like that, there is an interim order in this.
Beg your
That day, without any argument, there was an interim order in this.
No, they were in caveat, my lord. There was.
No, I know that. When are you going to argue this?
9th, my lord, 9th.
No further adjournments.
No,
It's not on
no,
9th.
in fact, we are ready,
We'll have
my
it
lord.
on 16th. 16th.
I request for 9th, my lord. 9th.
Because it takes time, this matter.
Yes,
There are so many matters on 9th and 10th.
Yes.
16th we'll have no adjournments.
Yes.
Finally, this matter on 16th, no further adjournments.
Interim order.
Interim order earlier granted is extended till then. Yes, next.
Serial number 27, S. Maheshwara, Pradeep B for appellant. T. N. Madhava Reddy.
For the appellant in
Yes.
involvement of the vehicle is questioned.
No, we'll do one thing, before taking up these matters, in list number 3,
Yes,
wherever there is any interim order and urgency, that we will take up first.
yes.
List number 3, extension of interim orders.
Serial number 7.
Huh?
Serial number 7.
Huh.
I am for the petition.
List number 3, serial number 7.
Serial number 7, yes.
For admission.
What interim order is need to be extended?
Interim order,
Huh?
interim order to be extended.
Interim order is extended. List this matter on 21st April.
25th April. Yes, for the response.
21st April.
21st.
Next.
Serial
8th.
number 9, my lord.
My lord, serial number 5, my lords.
I will solve. I will solve.
Serial number
1 minute.
1.
Not, there is no, serial number 8,
Serial number 8.
third list.
Third list, serial number 8.
My lord, interim order may be extended, my lord. It's a transfer petition filed by the wife, my lord.
Interim order is extended. List this matter on 8th of April. Yes, 9.
Serial number 9.
Much obliged.
9.
Served the copy in panel advocate, my lordship. R1, R2 and R4 unserved, my lordship. Served the copy in panel advocate Swamini Ganeshan, my lordship. Respondent number 2 and 4.
Which case?
Serial number 9.
9.1.
9, what is panel counsel in a CP?
9.1, my lordship.
Huh?
9.1.
I appear for the BESCOM. BESCOM panel advocate.
You appear for?
The BESCOM.
BESCOM is a respondent
Yes,
Respondent, my lordship.
in a CP.
CP, PNDC.
Huh?
PNDC.
I have not received a copy. I'll just check it up. So far as the respondent is the BESCOM, in respondent number 2 and 4 have been arrayed as BESCOM. So that is what they're just seeking to take and.
Transfer petition on the CP.
List 9 tomorrow. We're not able to understand this. List 9 tomorrow. Yes.
9 tomorrow.
Tomorrow, if not tomorrow, list on Monday.
Monday.
8th. 10.
My lord, I am for the petitioner, my lord.
Yes.
It's a transfer petition.
Any stay in this?
Yes, my interim order is there, my lord.
You appear for the respondent. This also on 9th. Interim order granted earlier is extended till 10. 11.
11. 10 over 11.
11.
11. Shrikant Patil. B.B. Sidramaya.
This also listed on 9th. If interim order is there, extend.
Cell number 12. Chandranath Adiga K.
Look at it. Interim order is there, extend, listed on 9. Yes.
Cell number 13.
Adjourned, I think 13.
13 adjourned. Cell number 14.
Paper conditions.
Rajshek.
Only tomorrow.
Tomorrow.
Cell number 15.
Tomorrow it
adjourned.
may not be possible. It's already 4:30.
Yes.
It will come on 9th.
9
Yes.
4.
Hmm.
Cell number 15 adjourned. Cell number 16. Gaurav.
Look at it. Wherever interim order is there, extend. This also shall come on 9th.
9 4.
Yes, 17.
Cell number 17. Girija Patil.
From respondent, madam.
Oh.
Myself is no objection regarding that. No objection to transfer the case.
No objection to transfer.
Oh, allowed.
17.
Then
Party person.
there should be
Respondent.
some memo, something.
He is
In party, I
respondent,
respond.
not yeah.
I got notice on 22nd.
CP is allowed, the party in person present before this court submits that he has no objection to allow the petition. Yes. Next.
Cell number 18. Ravindranath M. Sridhar T.
Paper per respondent.
Huh?
Kindly please extend the interim order.
Tomorrow. Yes, tomorrow. Interim order is there, extend. Look at it before. 9. If I say tomorrow, that's 9.
Yes, ma'am.
Yes.
Cell number 19.
For the petitioner, my lord, fresh matter for
Andaraya.
issuance of notice.
Fresh matter.
Yes, ma'am.
We'll hear it.
Yes.
They'll take out the fresh matters.
Okay.
19. Next.
Cell number 20.
These are all fresh matters. Take these bundles out. Fresh matters, take it. Till 25, all fresh matters.
Yes, ma'am. Still number 19.
Serial 19.
Serial number?
19.
Uh-huh.
Fresh wife's petition, my lord, seeking transfer of petition from Bangalore to Shivamogga.
Distance?
Distance is more than 300 kilometers, my lord.
MC which year?
MC of the year 2024.
See. The petition is filed by the wife seeking transfer of the pending MC from Bangalore to Shivamogga.
Bangalore to Shivamogga.
Bangalore to Shivamogga, it is submitted, the distance is 300 kilometers, same like any other order. Stay. And interim order, the notice shall be served on the council, hand summons on the council appearing with respondents by 23rd. Memo shall be filed by 24th. If the memo is filed on 24th, list on 25th, or else the stay granted by the courts translocated. Next.
Deeply obliged, my lord.
K. Prasanna Shetty.
For the
Same.
petitioner, my lords.
From where to where?
From Shivamogga to Kundapura, my lords.
Distance?
150 kilometers, my lords.
Which year is MC?
23, 24.
Filed by?
Husband, my lords.
Why?
For divorce, my lord, divorce petition.
This petition is filed by whom?
My lord, wife, my lord, for the transfer of.
Same, this is 150 kilometers from
Shivamogga to Kundapura.
Shivamogga to Kundapur. Same in the earlier order, hand summons and all.
Serial number 21.
Yes.
VR Balraj. VR Balraj 21. List number 3.
List is matter on 9th.
Serial number 22.
Appearing for the petitioner.
Abhishek.
My lords, the petition has been filed by the wife, my lords, seeking transfer from Davangere to Shivamogga, my lord. Distance is 100 kilometers, my lord.
MC which year?
24, my lords.
Is from Davangere to Shivamogga.
Please, my lords.
100 kilometers, yes, same like in the earlier order.
Please, my lord.
Yes, next.
Serial number 23.
Yes.
23.
Petitioner, my lord. My lord, the respondent has filed MC petition seeking conjugal rights, my lord, before the Arakalagudu. I am seeking transfer the case from Arakalagudu to Mysore, my lord, 110 kilometer distance from Arakalagudu, my lord.
When is the MC filed?
My lord, MC filed my lord, on 10/1/2025, my lord.
10/1/2025.
I am the petitioner wife also filed a criminal petition before the
Considering the distance is, you said
10 kilometer.
110 kilometers. Stay, hand summons, same order in like other case. Yes.
Please.
Number 24. Manu Shankar, yes.
Wife filed the petition, present petition, my lord. Margaret to Tipton, my lord, 110 kilometers, my lord.
Yes, 110 kilometers. Which year is MC?
My lord, 2024, my lord.
Same order. Yes.
Cell number 25.
Challenging the order of remand, but
MSA. This we will have it on 9. Tomorrow it won't come because it's already 4:38.
after remand, my lord, now the proceedings are going on before the trial.
No, we'll have it on Monday because I need to hear it. Yes, Monday. Come back to that list.
One respectful submission. In list 3, serial number 3, my lord, it is a fresh matter, my lord. Wife has challenged the CP from Mysore to Bangalore.
List number 3.
Serial number 3.
It's coming up for orders.
My lord, the certified copy has not been produced, my lord. My lord, I have received along with the summons, the copy of the G&W petition, which is same annexed here, my lord, in this petition. So office has raised the office objection, my lord. It may kindly be dispensed with, my lord. The copy which I have received from the post from the G&W court Mysore.
Who asked? Who asked for the dispensation?
No, my lord, it was listed for council submission, my lord. So that is.
You should ask if something has to be dispensed with. You will ask, isn't it?
Please, my lord. I want.
Dispense with the so and so.
Please, my lord.
And then you have to ask it. You didn't ask it.
No, my lord. The copy which I have received from the summons to the court, I have produced same copy, my lord.
Which one you are seeking transfer of? What from where to where?
G&W petition.
So what I'm saying is saying the same reasons you should have said.
Please.
That may be dispensed with.
Please, my
you
lord.
Don't ask it.
I have wrote in the council submission as well, my lord, but office has raised that.
Dispense with is also one application.
Please, my lord. But wife has filed seeking transfer from.
Whatever it is, file it. Let's just matter on 9th.
Yes.
Lords, may.
Please.
My lord, list number 3, serial number 16, my lord.
Serial number 5,
List
my
number
lords.
3, serial number
My
16.
lords, it is marked as not pressed, my lords, dispensation, my lords. IA2 is for stay, my lords. It's a transfer petition, my lords. From Hassan to Bangalore, my lords. It's the husband petition, my lords. Husband is seeking transfer to Bangalore because, my lords, respondent is working in Bangalore, my lords. I have filed the documents also stating
We'll
that
not
he's
hear
working
it
in.
now. List is matter on 9th.
My lords, tomorrow, my
My lord,
lords.
on
Tomorrow it
submission,
won't come because it's already
Day
4:40
after
list
tomorrow,
is
my lords.
prepared.
Day after tomorrow.
my lord,
Huh?
on submission, my lord.
What is day after tomorrow?
Sorry. Apologies, my lords.
My lords, I
Yes.
make
On
one
submission, my
submission.
lord, list number 3, serial number 16, my lord.
Serial
Papers is
number?
not served. Serial number 16, my lord.
It is not here.
My lords.
16, it is ordered on 9/4.
9/4 it is coming.
Please, my lord, papers is not served on me. Kindly
So and
direct
so,
the,
when counsel for the petitioner in serial number 9, then counsel for the petitioner to serve the copy of the appeal memo, petition on the counsel for the respondent, yes.
My lord, I
Great.
make one submission, my lords.
Huh?
Serial number 26 in second list, my lords.
20? That's
26.
over long back.
My lord, this matter may be kindly have it on 17th, my lord.
16/4.
The other side is also there.
20?
17th, my lords.
6, my lord, serial number. My lords are given a
Because
date
we,
to 60.
in this case, what happens, we engage the senior counsel, my lords. The senior counsel is not
No, that
available.
is not the problem of the court.
My lord, kindly have it on 17th, my lord. 17th, my lords.
17th it is not possible. Thursday it's not possible.
Any other time except 16th, my lords.
22nd,
22nd.
22nd.
26th on 22nd. Yes. Come back to the list.
Yes.
Obliged, my lords.
My lord, serial number 9.
3.
Serial number 9, my lord. R2, R3 and R4 show the name is
Serial number?
It will come. I already adjourned the matter. We'll see. Yes, next.
It is on
interim or interim.
If at all it is there, where in all the adjourned cases, they will extend if it is there. Yes.
serial number, list number 3, but 27, 30. List number 2, serial number 27.
Yes, Pradeep.
This case, my lord, the involvement of the vehicle is questioned.
Where is the counsel in the next, the connected matter?
His colleague will come regularly.
Madhava Reddy.
Already colleague will come regularly. I will inform tomorrow, day after tomorrow. Any day.
This matter is partnered on so and so.
8/4.
9/4.
Serial number 28. Serial number 28, Rajiva BC.
Matter to appear for appellant one. Ready.
Yes.
Tomorrow, day after tomorrow, will all be.
The claim petition is dismissed against both the insurer. I am the insurer of the petitioner's vehicle. And the other vehicle.
What?
I will argue, my lord. I have, I got 2 points I have got. I will put forth your lordship, my lord. I will try to.
Tomorrow?
Please.
Tomorrow?
Yes.
28, 29, next third list. Tomorrow, all MFAs in third list.
Melody, it may be taken up on day after tomorrow, my lord.
Day after tomorrow. is-
Day after tomorrow.
Day after tomorrow is what?
Thursday.
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 Please.
That pattern will come from tomorrow because we have heard it.
See.
Tomorrow, third list. Day after tomorrow, third list. Yes,
Hello,
next.
second.
4 in the first.
Serial number 29, 29, 28, 29, 30. All are on. 31 urgent, 32,
Same.
33.
Day after tomorrow. No, tomorrow. They have asked for day after tomorrow, remaining tomorrow in that list. Third list.
Yes. Serial number 33.
I am for appellant, my lord, only quantum, my lord. Ravi Samprati.
Tomorrow.
Serial
Yes,
number
next.
34.
Yes, I IP for the appellant.
Tomorrow?
Any?
Third list tomorrow.
Serial number 31, it may be taken up day after.
That's what I said day after.
Please.
Yes.
Serial number 36, 35 urgent,
Now in
36.
tomorrow, all those matters are coming, 250. What I have told him is to prepare the list as per the company wise. I asked the registry itself to prepare the list as for the company wise. And now I'm also telling him with the death case or the case of injury, that also I'm asking the section to verify where Raghu is here. So even whether it is a case of injury or death, if possible, because a short notice to you, if possible, mention that also. So tomorrow, like your officers are also coming, we'll take up these matters at 4:45 after the court hours. And
List, Mr. Raghu has to give the list to the company also. So they will need 1 or 2 days time to.
no, that is true. What I'm saying is tomorrow they're coming. So we'll look at it like how they want to go forward with that. Tomorrow 4:45 we will see first. Then anyhow for settlement and all you require time. That's a different aspect. First of all he will segregate. Then after that, as you all saying, basing on each company on one day, that also you can ask the feasibility of your officers tomorrow when they come.
Please.
So till 35 will be there in tomorrow's list.
Yes,
From 36 you should give some other dates, 36, 37, 38, not in this roster.
yes,
Send, let it come in June.
yes, ma'am.
Give some dates in June.
June.
Yes.
That is
Not
on,
not 38. 38 will come.
Yes, ma'am.
38 it will come.
Four minute day after tomorrow.
We'll see this matter on that day. Yeah, the this matter on 9th, 38.
Yes.
Yes.
4 day after tomorrow.
4 months.
Day after tomorrow.
4.
4 minutes.
You ready?
Day after tomorrow.
Day after tomorrow, 4.
Serial number?
4 in list number?
First.
Two.
Sorry, list number 2.
2 months.
Day after.
Pass over, ma'am.
List number.
Yes.
List number 3, serial number 6, my lords.
List number 3, serial number 6.
Clarification was sought with respect to the successors of the appellant, original appellant, my lord. Lord, I had filed a G3 in this. With respect to this on last
List number 3.
List number 3, my lords. Serial number 6, my lords.
What is this?
My lords, in that IA was filed, the original appellant was demised after the decree of in the first appeal, my lords.
Yes.
Now I have filed with an application for to pursue the case, my lords. With respect to that, one clarification was sought. Who was the successors of the original claimant?
You are saying that as per the so-and-so issued by the revenue authorities, so-and-so are the successors.
Please, my lords.
All of them should be on record.
My lords, they are, my lords.
Where are they?
My lords, if in MSA 174.
Give that. Why 174? It should be in everything. It should be respected.
My lords, I'll rectify, my lords.
No,
My lord, in MSA 183, he himself, my lords, the claimant, there are no LRs. With respect to the next. With respect to 172, my lords.
For their respondents.
With respect to 172, that is 6.1. The LR was
83.
183, he himself, my lord. There are no LRs. There are claimant. He was the claimant. He was the first appellant. Now he is the appellant.
So as far as that is concerned, why then there are all you are connecting 6.1 and all. How are they connected with that?
My lord, no, these are different cases, my lords.
My lord, it was connected for this reason, my lord,
It was
because
So
same
what we
occurrence
will do is,
please, my lords,
to clear to do all this, the confusion. 6 we will order first. 6 we will order first. Give 6 file. Already your IA is ordered.
For implement,
It's ordered.
it is ordered, my lord.
Only in
The-
183, my lords.
The IA number 1024 is filed to condone the delay of 1460 days delay in filing the petition. Then counsel appearing for the R1 and R2 submits that The proper reasons are stated for the said delay, considering the fact that these are all the land acquisition proceedings proceedings. This court deems it appropriate, balancing the interest of both the parties. This court deems it appropriate to condone the delay, same on the condition that they'll not be entitled for the interest for the said period in case of enhancement.
Please.
Yes. Next, the same order. It is submitted by both the counsel. It is submitted with the land counsel for the appellant that in the similar matters, this court had set aside in respect to the similar acquisition, the court had set aside the order of the reference court and remanded the matter for fresh consideration. In the light of the orders passed in MSA number so and so, this court is passing the following order, same order in all, whatever their content, same.
Remand.
Yes. So next, give me 6.1. 172.
Please, my lords. My lords, in 172, since LRs were brought on record in LAC appeal itself, so there is no LR application in this, my lords. The only IN is Section 5 of Limitation Act and impleading for the respondent number 2.
No. There is no leave petition in this.
No, my lord. In 172, no. Because the LR was brought already on record in LAC appeal. In the pendency of LAC appeal, the LR was brought.
Before the reference court itself.
Before the first appellate court.
First appellate court.
Yes, please, my lords.
No, in the land acquisition matters, what is this LAC again? Appeal?
My lord, for this reason, my lord, if the amount, the compensation amount is less than 10 lakhs, my lord, then it will come to the sessions court.
I think jurisdiction aspect in LAC appellate court is high court only.
No, my lord, that is with regard to new act. New act, it will directly come to the high court, my lord. But before, as per the old act, my lord, if the amount is, compensation amount is less than 10 lakhs,
In
it
this
will come.
also, 1403 days delay. IA is not ordered.
Not ordered.
IA number 2 of 24 is filed to implead the beneficiary, that is
Kaveri Nilavari Nigam.
Kaveri Nilavari Nigam. In the similar matters also, this court has already ordered those applications, and Mr. B.R. Prashant takes notice on behalf of respondent number 2, a proposed respondent
R1 also,
number
Your Lordship.
2, and the letter counsel for the appellant shall carry out the necessary amendments. In the earlier matter also, you have done non-amendment.
183, I have filed the, I've carried out amendment and I had filed the petition.
Then in the earlier matter, petitioner has already filed the amended cost title. So in 6.1, the amended cost title shall be filed. Then same order and accordingly remanded. AGA takes notice for RA for respondent number 1. Next. Next.
My lord, in 174,
Yes.
I've asked for the leave in IA number 2, my lords. My lord, with respect to that, I had filed genealogical tree in page number 81. My lord, there was small error in that genealogical tree. For that, I have filed a memo with the appropriate genealogical tree, my lord. In that, if I lordship permit to point out,
We'll see on 8th. Unless this matters on 9.
9.4.
6.2, 3, 4, and 5.
Yes.
We'll hear it like I'm not able to apply my brain
Please,
on that.
please, my lord.
Yes. Then grant, yes.
Lordship, so on submission, list number 3.
On the law ordered. Yes. Not
Yes,
all
sir.
matters. Only, first of all, leave granted, then only delay will be condoned. Yes.
List
Yes.
number 3, Your Lordship, serial number 17.
1 minute.
List number 3.
Serial number 17.
Serial number?
17.
Yes.
I apply for the petition. There is interim order in this case, no, that has to be extended.
No, it will be interim order.
17.
Interim order.
Has to be extended, no. There is an interim
Wherever
order.
it is there, it will be extended in all the adjourned matters.
Please.
Which one? 17 is allowed. The party in person appeared and said that he has no objection.
Please, ma'am. Much obliged.
Yes.
ಎರಡು ಇದೆರಡು ಡೀಲಿಂಗ್ ಇವ್ರೆ ಅವರೆಲ್ಲ
ಮೆಮೊ ಹಾಕ್ಬೇಕು. ಮೆಮೊ ಬೈ ಅದೇ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್
ಕೊಟ್ಟ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 22 ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಏನಾಯ್ತು ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್ 22.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ.
ಅದು ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನು ಮೇಡಮ್. ಅದೇ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಮೇಡಮ್ ಹೇಳ್ತಾರೆ. ಅದು ಇದು ನೋಡ್ಬಿಟ್ಟು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ನಾವು ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ.
Item list 3 serial number 5.
ಹೇಳಿ.
Item 3 serial number 5.
ಸರ್ ಹೇಳಿ, ಲಿಸ್ಟ್ ನಂಬರ್ ಯಾವ್ದು ಹೇಳಿ?
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 22.
ಅದು ಎಲ್ಲ 9/4ಗೆ ಸರ್. ಇದು ಟುಮಾರೋ, ನಾಳೆಗೆ. ಲಿಸ್ಟ್ 3 ನಲ್ಲಿ
ನಾಳೆಗೆ
19 to 22 ಟುಮಾರೋ.
ಓಕೆ.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ
ಲಿಸ್ಟ್ 3 ನಲ್ಲಿ ನಾಳೆಗೆ ಸರ್ ಅದು. ಅವ್ರೇನು ಸೈಟ್ ಮಾಡ್ತಿದ್ದಾರೆ
ಮೇಡಮ್? ಇದೆರಡೇ ಡಿಸ್ಪೋಸಲ್ ಅವಾರ್ಡ್ ಅಂಡ್ ರಿಮಾಂಡೆಡ್.
ನಾಳೆಗೆ
ನಾವು ಬರೆಯೋದು ಮಾತ್ರ ಇದೆ. ಇಲ್ಲಿ ಇಡಿ ಮೇಡಮ್, ಬರ್ದಾಕ್ತೀನಿ. ಅಲೋಡ್ ಅಂಡ್ ರಿಮಾಂಡೆಡ್ ಫಸ್ಟ್ ಟೈಮ್ ಮಾಡಿ ಇದೆಲ್ಲ
ಆಮೇಲೆ ಅವಳು ಇವಳನ್ನ ಕರಿಬೇಕಲ್ಲಪ್ಪ.
ಅದು ಮೇಡಮ್
ಏನು
ಮೇಡಮ್ 3434 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವ್ದಕ್ಕೆ?
29 ಇಂದ ಡೇ ಆಫ್ಟರ್ ಅಂತ
ಅಪ್ ಟು 28 ವರ್ಗು ನಾಳೆ.
ಅಲ್ಲ ಮೇಡಮ್, 28
ನಾಳೆ
ನಾಡಿದ್ದು
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಅಂತ. 28 3 4 ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ, 28 29 ಥರ್ಡ್ 30 ಆಮೇಲೆ 32 ಎಲ್ಲ ಡೇ ಆಫ್ಟರ್.
32 ನ 24 ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಾಳೆಗನಾ?
ನಾಳೆ ಕೊಟ್ರು ಮೇಡಮ್. ಅವರು ಕೇಳಿದ್ರು ನಾಳೆಗೆ ಮಾಡಿ ಅಂತ. ಇಲ್ಲಿ ನೋಡಿ
ರವೀಶ್ ಬೆನ್ನಿ 32 ಹೌದು 32 33 ಎಲ್ಲ ನಾಳೆ ಇಲ್ಲ 24 ನಾಳೆಗೆ.
32 33 34
ನಾಳೆಗೆ 36 ಒಂದು 36 37 ಜೂನ್ ಅಲ್ಲಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಡೇಟು. 36 and 37 ಜೂನ್ ಅಲ್ಲಿ. ಒಂದ್ ನಿಮಿಷ, ಜೂನ್ ವರ್ಕಿಂಗ್ ಡೇ ನೋಡಪ್ಪ ಅಲ್ಲಿ.
2 3 4 ಎಲ್ಲ ವರ್ಕಿಂಗ್.
ನಾಳೆಗೆ ಯಾವ್ದಿದೆ? 2 3 9th
ಜೂನ್ 9.
ಜೂನ್ 9 ಕೊಟ್ಬಿಡಿಯಪ್ಪ.
36 37 ಜೂನ್ 9 ಕೊಡ್ತೀವಿ ಮೇಡಮ್.
36 37 and 38 ಒಂದು 9/4ಗೆ ಆಯ್ತು.
ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮೇಡಮ್. ನಮ್ಗೆ ಲಿಸ್ಟ್ 3 ಏನು ಅರ್ಥ ಆಗಲಿಲ್ಲ. ಅದು ನಾಳೆಗೆ ಬರುತ್ತೆ ಎಲ್ಲಾನು ಬಾಕಿದು 1 ಇಂದ